All set?
All set.
The first item on the agenda is welcome and introductions. And in the interest of saving time, I'll say welcome, and I don't think we need introductions. We do have, I think, is it Ann Willie joining us in Albany? Can you hear us? Ann, can you hear us?
She can.
Nope. It looks like we lost the picture as well. For all the time we're waiting, we can see her, we can hear her. As soon as we start, it goes.
Sounds are ready.
We might have some issues with this because I think IT wasn't able to have someone there.
Oh, there she is.
Perfect.
Can you hear us, Ann?
Yes.
All right, great. I just indicated our first item agenda was welcome and introductions, so welcome. I take it that you're the only one in Albany right now?
Yes, Jim hasn't come yet, but
He sent us a text indicating that he'll be about a half hour late. So I expect him. We are going to get started. The first item on our agenda is a review and approval of the meeting agenda. Do I have a motion to accept the agenda?
So moved.
Do I have a second?
Second.
All in favor?
Aye.
Anyone opposed? All right, that carries unanimously. The next item on the agenda relates to a matter that I anticipate should be discussed in executive session, so I would ask if we have a motion to go into executive session to discuss information relating to the current investigation which could jeopardize the investigation if disclosed, or that may lead to promotion, demotion, discipline, suspension, dismissal, or removal of a particular person. Do I have a motion? Do I have a second? All in favor? Anybody opposed? All right, that carries unanimously. So we are going to go into executive session. I do anticipate that the executive session will probably last several hours. So I would think that...
Albany, can you hear us?
Hello, we hear you.
Okay, we're going to do a motion to go back in an open session.
Kathy, you made the motion?
Yes, I'm
Seconded.
Marvin, second. All in favor?
John.
Thank you.
You know. What?
The question was good.
Yes.
Yeah, saying Wednesday, no, they're saying not.
You gotta appreciate the political fallout. Very simple. They were right. They were right to fire Nick. And that's what's
That's what it's going to say.
yeah.
Even though she would that, when you're supposed to read them, it just was before she was.
Okay, everything is still on, being recorded because we didn't stop, the tape is not stopping, so.
Hey, Kathy, can I bring people in there from the labs?
Scott, how are you?
How you doing?
I'll be we're done. Hey, Kathy.
Sorry for the long wait.
We have people coming in Albany.
Hey, Phil. How are you, Phil? Good. Hey, Maureen.
They passed the
Very, very effective. I have to say. There will be accountability for all discussion. That's it.
Are you staying to the end?
So what?
Staying to the end?
Oh yeah, because I wanted to get to that game. I'm going to set up, making a motion, but set up a subcommittee to work out the logistics of it. I'm going to ask you to be on that committee. Who? You. With me, with her, with Catherine Levine, she's a hair analyst for 20 years, and Melissa Smartry. And you would be on it primarily to deal with the whole problems of notifying defense.
We'll say be on your toes for that business of my lecture.
For the what?
My lecture.
Oh, yeah.
Because these guys came on. So
Yeah.
I don't know what they think they're going to stop it. Maybe they can.
Yes, we have another issue like that with, we have an AP case where Barry intends to put on Saul Casson, who teaches at John Jay.
John Jay, right.
And the Attorney General has given us notice that they will not allow Saul Casson to testify because of this obscure rule that says that state employees should not be allowed to testify in any proceeding at all or take a position that's adverse to the state of New York. So much for academic freedom.
Where did they?
I'll send you the email for it. It's really.
Did they call the public officers law?
It's quite amusing.
It's the same issue.
You know, I went back online after. No, I went back online after I spoke to you. I found a J-COPE analysis of 73A, 74, and 80. I don't think it applies to us.
Yeah, no, we should.
It's not an honorarium. They define it as not an honorarium.
Keep the below the 84
They define it as no coverage.
See, there's no sporting events for you in the county. New York team is just awful this year.
You have very little problems.
It's just terrible.
So
If someone offered you free tickets to a Giants game,
but
you'd
maybe
turn
we're going to find out differently.
You would say this because they already did, and you turned them down.
We're missing Jim Murphy.
It's terrible.
You thought we were done.
I'm going to start encroaching on my little territory. I'm not saying anything because I'm a nice person.
Jesus Christ. People are so territorial. Look at you, you got like extra stuff.
Because I got extra stuff.
Look at you. I got this tiny little area, and you can have a finger sticking out.
Some of them.
All right, I think we'll get started. We've enough people here to start. So we're back in open session after an executive session. I will indicate for the record that the commission took one formal action in executive session. And that action was to request ASCLD Lab to conduct a management review of the OCME forensic biology laboratory. Okay. Characterize that correctly, right? With that, we'll move on. The next issue on our agenda is review and approval of the minutes. And there will be minutes of first the April 10th meeting. There are amended minutes. There are issues raised by Commissioner Bouchek. Also the June 26th minutes and the August 22nd meeting minutes. And all of those minutes have been provided to the commission members. Is there any comment or any discussion? And if not, do I have a motion?
Mike?
Yes.
Simple spell check on page 11 of the April minutes. The word good in the first line of the first paragraph should actually be goose.
I caught that.
page 11, word good versus word should be good.
Somebody said
She's right.
Has cooked their own, not they cook their own.
Thank
flour.
you. We will make that change. Anything
I
else?
didn't read those.
Smarty pants.
Move to approve?
Second? All in favor?
Aye.
Anyone opposed? All right. The next issue we have, or the next set of issues, deals with laboratory accreditations. First laboratory we have on is the Montgomery Crime Laboratory. Brian?
Albany, you should have representatives from the Monroe County Crime Lab there. Commission members have been provided with the following documents for review. There is finding recommendation from the DNA Subcommittee dated September 27th, letter from ASPAD Lab dated August 30th, 2013, final ASPAD Lab assessment report dated August 29th, accreditation certificate dated August 29th, as well as a scope of accreditation, and a compilation of mock cases. So you should have that in a separate binder. So right now, essentially these documents are open for your review. The laboratory has gone through their ISO inspection, and they're also seeking to add the discipline of digital evidence. So does anyone have any questions for the gentleman? And could you identify yourself from Monroe County? You got John up there.
John Clark, Laboratory Administrator.
Is anyone with you, John?
Yes, our technical leader from DNA, Alan Colquhoun, supervisor from drug chemistry, Jim Wesley, and our technical leader of digital evidence, Andrew Wilkinson.
Thank you for being with us.
I just have
Thank you for
a
having
question. I just have a question directed to the commission. All of the documents that Brian just mentioned are marked confidential document, not for distribution. That disappears after today, right?
No, what happened is the documents that are posted on the web
Right.
will not have that. I think there was an omission in the past, but any documents that are in the binder, and you'll notice even news articles have that. Anything that's in the binder gets that
But
stamp.
all this is going to be published.
It's already published,
It's online already. Okay.
without a stamp.
Without the stamp.
Correct.
Okay.
I have a question. John, Kathy Corrado, I have a question for you. Just in looking at the digital evidence mock case reports, the lab reports, I think what I noticed was that the disclaimer that all the labs are putting on the lab reports now about this document does not represent the entire case file. I noticed it wasn't on there. I'm assuming that was just maybe an oversight. Do you plan on putting that on these reports as well?
Yes, that will be on all future reports.
Okay, thank you.
Does anyone else have any questions for Monroe County?
Just looking at the mock, could you explain a little bit more what you did with these mock cases and your mock trial? How did that work? Who participated? Because it's really hard for me to figure it out just looking at the binder. How did that work?
The mock cases were made up by several laboratories, 2 laboratories from New York State that are accredited in digital evidence, Onondaga and Westchester County, and also I believe one of the mock cases, or 2 of the mock cases actually, came from a private vendor, which is also ASCLD Lab accredited.
But if there, I didn't see an answer key here, or is there one?
Let me refer to our technical leader in digital evidence, Andrew Wilkinson.
Afternoon. The mock cases that were provided by the other labs, when we completed those mock cases, they were sent for the technical, and during that time, since they went to the people who drafted them, they were able to determine whether or not we accomplished the standard that they would set forth in that mock case.
I guess what's confusing to me is, we get this big binder, right, with all the materials that appear to be a mock case, and I have no idea. What did you get, a thumb drive to look at, and then you had to extract things from the thumb drive, and then they told you whether they got everything or not? It's really hard. it's impossible to figure out what the task was, what the answers were supposed to be, how you fared, and what the issues that presumably are being tested in the mock presentation are. I couldn't figure it out from looking at this.
We received a service request along with what would be considered the original evidence. The service request detailed exactly what we were supposed to search for, along with a mock search warrant detailing our authority, and the evidence typically was either a small hard drive or a thumb drive. And I refer back to what I stated previously. When we submitted it back for the technical review, they stated, when we got a positive technical review back, we were under the assumption that we discovered everything they were looking for, seeing that they were the ones that created the mock case.
Well, would it be possible to provide us with there must be some, ordinarily with proficiency tests, you get some key that says this is what you're supposed to find, this is how it's found. Did you get 100% of everything? How is it defined? Is there some way you could send us information that tells us what this is supposed to mean? Because I can't figure it out just from reading it. Am I missing something here? Can you direct me to a page that shows what the answer is and what the test you were supposed to have accomplished is?
Did you get that information back with the... No. Okay, we can send you that information, because I don't have those documents with me right now.
I just got to say, I'm concerned about something that's supposed to be a proficiency test that doesn't lay out what it is you're supposed to find and what the answers were and what you got and what you didn't get.
Mm-hmm.
I don't know if anybody else could figure this out. I couldn't.
Is the answer key that he's looking at, is that done by someone other than the technical reviewer, or is the technical review the same?
If you look at the one of the first proficiency tests on here in your bound material, put together by ISFCE, doesn't look like it has a page number, but it's proficiency tests 11-0101. This is your report for this one.
Yeah. Yes. Yeah, that's the tech review. Dana at Westchester.
In the first one anyways, Gary, it's all there. It says what they were asked to do, then it says how they're going to evaluate the results, then their results are there, and then at the very end, there's a comment on what you found and whether that's what they expected. I didn't look at all of them, I did look at that first one.
And I would like to point out that, in my understanding, John, correct me if I'm wrong, but these are mock cases that were done to simulate casework so that SCUD Lab would have something to review when they came in to see how you were doing casework. This is not your proficiency test or competency test for your examiners necessarily. These are mock cases. Is that correct?
That's correct.
Okay. So
Yes.
I think when our laboratory made some of these mock cases up, and we did submit what the expected results were. It's my understanding that is checked as just part of the mock case, but that's not. This isn't being used as their proficiency test. If that makes sense.
So I guess the thing is, it's maybe not the cleanest presentation, but essentially what happened is the technical reviewer is verifying that the result provided to them, and please don't let me paraphrase, John, or or Andrew, if I'm incorrect here, what you're saying is that the technical reviewer, by checking off the technical review box, which agreeably is a little bit nebulous, where it says, if I can find one,
Says, are the conclusions reasonable and within the range of acceptable opinions of peers within this discipline?
which seems to be a standard tech review, so you're kind of taking that to another level. While the tech reviewer signed off on this, since the tech reviewer substantially created the mock case, they're also attesting that this is in fact the correct answer. Is that
That's
true?
correct. Yes.
So while not the cleanest presentation, there's no physical requirement of how to go about doing this, so I think maybe we can also give them a little more guidance in the future as to how to do that, and I'll try to do that through OFS.
Yeah, I have to say, I can't follow it. I mean,
what you're saying is you would like to see a document that says what the expected results were as well?
yeah, in other words, I mean,
They have that.
yeah, I mean, there must be some, in other words, ordinarily, you would say, we're sending you X number of things to analyze, for, I don't know, annelids, for, see if you can get a DNA profile from X number of pieces of evidence, and here's what you're, so you would be able to say they were able to retrieve these results, they didn't find other results, or they found everything they're supposed to find, but that would be defined in advance so that we would know what it was, and there would be documentation that they got the expected results. This is...
Well, I think there is documentation in here that they got the expected results. There's the technical review sheet by someone from an outside lab saying that the conclusions are reasonable and within the range of acceptable opinions of peers within the discipline.
Well,
It doesn't...
That's a little vague.
No,
I mean, it doesn't mean anything. I mean,
well,
you should...
I disagree. You say it doesn't mean anything.
No, it means that this tech reviewer thought that was reasonable, but it doesn't tell us, did they detect all the data that they were supposed to detect? Let's say they didn't detect all the data they were supposed to detect, but what they didn't detect was reasonable within the realm of people in the discipline. Well, all right, but I can't figure that out from this.
No, I think if you want, it seems that there's more documentation. If you want that, I think it's reasonable to make a request for it.
I would request it, but I would also note for everybody in this new discipline that, there needs to be a little bit more specificity so somebody that is actually trying to read it can figure out what the test is and what the results are, other than the conclusion it was within reasonable limits. I don't, that's not, I don't think adequate scientifically for these purposes.
Any other questions for Monroe County about any of their ISO audit? If not, I'd like to make a motion to grant Monroe County New York State accreditation in drug chemistry, biology, trace evidence, firearms, tool marks, impressions, serial number restoration, and digital multimedia evidence for the period mirrored by their ISO accreditation. I do want to note that the way the ISO is going is because they haven't done actual casework. Once we provide the New York State accreditation, after a 1-year period, ASCLD Lab will come in and perform a full ISO audit of their digital and multimedia section, looking specifically at the new casework that they've done. So that's the motion on the table. Do I have a second?
A second.
Any discussion? All in favor? Anyone opposed? Any abstentions?
I'm abstaining because for reasons I stated, I can't track this. I don't understand it.
Is that abstention just with regard to the
It's in regard to the digital
and
evidence.
multimedia evidence?
Yeah, I'm flagging concerns about that.
I voted for.
Kathy, do you have everything
Sorry.
quantified?
Yeah.
And
You should look at my right ear. It twitches.
could you just summarize it for us? What the yeas, nays, and abstentions were?
Oh, you're testing me. It was unanimous to accredit the Monroe County Crime Laboratory for the disciplines as mirrored in their ASPAD accreditation. Abstentions from Marvin and Barry, and the rest are Rest
I
are
think
yays.
Gary's abstention, if I was clear, was only
It's
with
limited.
regard to digital and multimedia.
But we only have one motion to accredit, so
Okay.
I'll make that note that it's digital.
Thank you, John.
Thank you.
Thank you.
The next item on the agenda is the Erie County Central Police Services Forensic Laboratory. Commission members are provided with the following documents for review. There's a letter from ASPAD Lab dated September 17th, 2013. A letter from Dr. Simic to ASPAD Lab dated September 4th. Corrected full assessment report dated September 12th. Various cards received by the Office of Forensic Services. There's no vote required. This is for informational purposes only. And we have Dr. Simic in Albany if people have questions.
With regard to no vote, why is it, if you can explain just why there's no vote at this time?
Sure. At this point, it's an informational purposes. Their accreditation is not, this is not a vote to accredit them. They don't have all their documents back and forth yet to ASPAD Lab, and all their cards haven't been accepted to fully resolve it. So at the next stage, they'll move forward with that.
In addition, I believe the DNA subcommittee has also requested additional information from them, is that correct?
Yes. And at the September 27th, thank you, the September 27th DNA subcommittee meeting, members of the subcommittee also asked for Erie County just to present additional information about one of the cars that's here and a more detailed report.
And that report is going to be made at the November 15th
Correct.
DNA subcommittee meeting?
Yes, the next one.
I just have one question, Jack. What method are you using for construing mixture statistics? Which one are you using?
Well, if it's a straight mixture, we will use the standard mixture stats that are in pop stats. And depending upon the ratio of the contributors, we might have to go to a restricted CPI.
Well, do you use true allele? Do you use FST? Do you use any of these other kinds of methodologies?
No, at this time we are only using pop stats, and we currently are in the process of purchasing Armed Expert. And that's hopefully going to be very shortly. Purchase order should be released.
Hold on, sorry, John, you're going to purchase
Armed Expert.
as a DNA interpretation software?
That's the name of the company.
Yes, and it also follows all of the recommended statistical guidelines that are currently in place and that are recommended by all the experts that are out there doing all these symposiums.
Yeah.
Right. The one thing, just as a quick adviso on that, that's going to just have to be brought before the DNA subcommittee. Right now, the DNA subcommittee has approved, and the commission has approved the use of true allele, but they have not approved an FST, but they have not approved Armed Expert, to my knowledge.
Now,
I am aware of that, and I have spoken to Jack Valentine, and I do know that we're going to have to present our validation studies to the DNA subcommittee for their approval before we can use that.
Okay, perfect.
now I would like, just for the record, if I think it might be helpful here, is there some way, Mike or Brian, to get from all the different labs in this state the different methodologies that they're using with respect to mixtures, whether it's going to be FST or True Allele or Armed Expert? And I'd also like to know from the laboratories how much all of those costs. I remember that when we had the presentation with respect to True Allele, about which I had concerns and asked a lot of questions, because I know unfortunately that the video of that is wound up in court proceedings in various different places around the country. But my recollection may be wrong, but I thought that to get a license for that, you had to pay $125,000. Is that right?
It was very high. I don't remember the number, but it was, for my lab anyway, it was cost prohibitive. I know, as John said, there are a number of other companies out there now. Armed Expert, I think, is collaborating with STR Mix, which is another group, and my understanding is they're going to combine. And I believe NIST is also doing some studies on a bunch of these and comparing them. I think those of us that are, I wrote it in my latest DNA grant to purchase one of these, so I'm kind of hoping that we get some data so we can make decisions based on cost and which ones are validated.
I would just like to know, for this commission, because, I realize that we have a DNA subcommittee, but this is a matter of extraordinary concern, I think, because We now have proliferating methodologies at various different costs where in the same low template DNA, you're going to get different results in different places across the state.
Depending on the software.
Depending on the software, and it, you know, and I'm just pointing out, Bill, for, you know, your purposes and for purposes of an organization like the Innocence Project, right? You know, for prosecutors, for defense lawyers, for people that are trying to figure out what's going on here, you know, that's kind of a problem when you have the same starting material and you're going to get different results depending on which software. And this is something that I really think merits our attention. There's cost factors here. We received at one of our Innocence Project Innocence Network meetings a presentation from John Butler and others from NIST about these things, and it's really mind-bending. Okay, so this is troublesome, and I would really request Brian and Mike and Kathleen that, you know, we should get a full inventory of what labs are doing, how much it costs, which methodologies they're using, so we can have some understanding of that.
Yeah, but
Has
then
the
go.
DNA subcommittee looked at this?
I was just going to say, Perry, go beyond that and ask why, which one's better? Why is Jack picking Armed Expert, and what do we use, Kathy?
Right now, we haven't purchased one, but
We haven't done, okay. I mean, why does one lab use one and I'd like to know the answer to that.
Yeah, and I think that there are, you know, there are serious issues with respect to that. And as we know, the OCME has its own system, which is being litigated in the courts right now.
The
FST.
Yeah.
I would just point out that I think there are issues there. My concern is for all of the labs, these are expensive systems, and if a lab doesn't have money to purchase one, then, you know, I think maybe we need to consider, if the DNA subcommittee is going to make a recommendation, we need to also consider funding sources as well.
And then there's Nora Rudin has one that is
Retriever,
seems
lab retriever.
similar to all of them, that she says they offer the system itself for nothing, although if you want to construe it, I suppose you have to pay for them to come in as experts. But this is a serious issue in my judgment.
Are these one-time costs, or are these yearly or recurring?
No, they're unfortunately forever.
They're forever, and some of them, like some require licenses that you have to renew. Some, they come in and help, they testify. Some, they'll train you so you can testify yourself. They're very different, so the processes they use are different, and the cost and training, and if it's one time or ongoing, that varies. So it is something probably we might want to have the DNA subcommittee weigh in on as well. I think it'd be nice to see what NIST comes out with, because I'm hoping that's a good comparison.
Kathleen, when we spoke with the head of NIST on this issue, Butler, a while ago, they had not endorsed any of the particular methods. Is it your understanding that they're actually going to be doing a kind of validation study on the various products that are out there now?
My understanding is they were looking at a number of them. I don't know which ones, and I don't know how extensive the validation, but I was at a meeting where that question was raised, and they said, yes, they were looking to do that. I don't know how far they are on it.
But I think that what's of particular importance to recognize is that it's not just that you get different results, they may express the significance of their findings in completely different ways. In other words, which presents trouble not just for juries, but even for the lawyers to understand what they're talking about with respect to the probability that somebody is or is not a contributor to a mixture. So it's not a trivial problem.
No, I don't think anyone's saying it's trivial. Would it make sense to ask the DNA subcommittee in the first instance to look at this and give us a report?
Yeah, I mean, I think that we should.
I'd move for that if we can.
Yeah, I think that
We have a NICLAC meeting next week that Kathy's going to be running. I don't think it'll be a problem to petition the DNA labs at that point to find out what they're using.
Yeah.
We can then have a correspondence from NICLAC to the DNA subcommittee saying these are currently the ones that are being done in the state.
We'd like to.
But to go further and actually look at the variables that Kathy just mentioned.
Sure.
The pricing.
Right.
Whether it goes on forever, whether it's a per case.
I'm not sure that the subcommittee will feel comfortable making policy decisions in that regard, but I think
No, but just a report on what the differences are, so this commission will know what those differences are.
I guess that's me. Everyone's smiling at me, I guess that's me. Great. Okay. Thank you.
Any questions, any other questions for Erie County?
Pricing approaches to it's a
All
competitive
right, there's
business.
no vote required at this time, so thank you.
Next issue on the agenda is the New York City Office of Chief Medical Examiner, Department of Forensic Biology. Following documents have been provided to commission members for review. There's essentially a letter from ASCOT Lab dated September 25th, along with a surveillance report dated September 25th, a letter to ASCOT Lab dated July 18th, and a letter to ASCOT Lab dated October 11th. So there's no vote required at this point. Again, it's one of those things for informational purposes. There are representatives from the OCME here if people have questions. Anyone have questions about the documents provided at this point? Okay. Thank you, OCME. Next item on the agenda is the New York State Police. Again, this is one of those situations that's for informational purposes. They're still in the process of finalizing their ISO inspection. So commission members provided letters from the New York State Police dated October 3rd, letter from the New York State Police dated September 27th, letter from ASCOT Lab dated May 31st, 2013, a full assessment report dated May 29th, various cards, a memo dated May 9th, a letter from ASCOT Lab dated May 29th, a letter to ASCOT Lab dated May 29th, and a scope of accreditation. And in Albany, we have Major Monroe, the new lab director. We have Don Fawnin, and he's sandwiched between two commission members. So if anyone has any questions about any of those documents that have been provided.
I think we should note, is Major Fawnin there?
He is, purple tie.
All right. It's tough to see it from way down here, but I did just want to note that I believe today may be your last day, if I'm not mistaken, in your current assignment. And I just wanted to thank you for all the hard work that you've done in the field and for your assistance with the commission's work over the years, and wish you well in your future.
Thank you, Commissioner.
Okay, and just also of note, I believe not on the official government dole yet, but your new lab director is up there.
Yes, please come up.
I believe he starts tomorrow, right?
That's correct. Hi, pleased to meet you.
Okay.
Yes.
Any questions for the new director? Or specifically, actually, any questions for Any questions for Major Monroe about any of the issues that you see before you? Okay, thank you, State Police. We'll revisit you later on the agenda. Okay, thank you.
Thank you.
Next item on the agenda is actually going to be slightly different than it appears. We're going to have the Westchester County Department of Public Safety Crime Laboratory, and the difference is yesterday at approximately 3:50, ASCOT Lab voted that they received their ISO accreditation. So unfortunately, you don't have a document in front of you. You'll have to trust me. I've got a trusting face.
No, I sent it up.
Oh, you got it?
Everybody should have it. Right?
I didn't think we had that one.
I just got it today in front of it.
Okay. So actually, you do have it in one of the additional documents you received.
October 15th letter, it's in the...
Yeah, so we received this, thank you, this is
I gave it to you.
a last hour, thank you, letter, where essentially what we have is, you know, you have several documents in front of you. Obviously, the most significant is this one here from October 15th, from yesterday, which is granting the laboratory their ISO accreditation. There's several other documents in there as well. If anyone has questions, we have Sergeant Dowd and the Quality Assurance Manager up in Albany. If there are no, well, this is not normally something we'd vote on because we have this new document. I'd like to make a motion to grant Westchester County Department of Safety Crime Laboratory New York State accreditation in firearms, tool marks, latent prints, digital and multimedia evidence, and crime scene for a period mirroring their ISO accreditation.
I have a question.
Please.
All right, with respect to fingerprinting, that's one of the things that latent prints?
Correct.
All right. Are you using the FBI protocol for the so-called linear ACE-V for doing your fingerprint analysis?
Yes, we are using ACE-V.
No. The FBI. The FBI protocols, are you familiar with the FBI protocols?
Specifically, which part of the protocols? Perhaps
Let's just lay it out.
Right. This commission managed to obtain from the FBI, when we were dealing with the whole issue of Nassau County, the current FBI protocols for analyzing fingerprints in the wake of the Brandon Mayfield case. And simply put, this would be a procedure where first the examiner would look at the latent print and identify all minutia or all what the FBI characterizes as red flags, potential artifacts. Then and only then would they look at any particular target print, and if there were any differences between what they then identified after looking at the target print, if they had any changes, then all of those would be noted. And then they go on to have other procedures for disagreements between different analysts and the documentation of all of that. Are you familiar with that protocol? And
yes, we do follow that protocol.
the one I'm just describing?
Yes, sir.
Okay, well,
Upon receipt of a latent print, we do a full analysis. We do we will scan it and we'll do annotations of the print, marking points of minutia, and only once we determine whether it's suitable for exclusion or for comparison, for identification, then we will go on to do any sort of comparison.
no, I'm saying something different. I understand that first you will analyze a latent for purposes of seeing if it's suitable for comparison, if it has a certain threshold amount of information. But when you're analyzing the print itself, does the analysis first call for circling all the different minutia and any possible information on that latent that may be an artifact, and then and only then comparing it to any particular exemplar or target print of any kind? Is that how you proceed?
Yes.
Right. Just so that to make sure that I'm not confused, would it be okay for them to send us their latent print protocol so we can take a look and see if you and I are not talking past each other, if that's okay?
Do you have any objection to sending us that protocol?
Absolutely not, Commissioner.
Thank you very much. And I will make sure that we will try to send to you, I think, in turn, the FBI protocol, because that was not generally available until this commission was able to get it,
All right.
for purposes of sending it to our labs.
I believe we have a copy right to get it.
We haven't.
Gets welcome for each other.
I would just like to say one quick thing. I just would like to congratulate the Westchester Lab and Sergeant Dowd for moving to the ISO accreditation standards. I think it's a really positive step. I know everyone has to do it eventually, but I just want to congratulate you. It's a big change, and thank you for doing that.
Thank you, Dr. Corrado.
Okay, just rehashing motion on the table. I'd like to make a motion to grant Westchester County Department of Public Safety Crime Laboratory New York State accreditation in firearms, tool mark, latent prints, digital and multimedia evidence, crime scene for the period bearing their ISO accreditation.
We have a second. All in favor? Well, any discussion? All in favor? Anyone opposed? Any abstentions? With one abstention.
Okay. Catch that, Kat? Next item on the agenda is the Nassau County Office of Chief Medical Examiner, Division of Forensic Services. Oh, sorry. I forgot a Westchester. Westchester County Department of Labs and Research, Division of Forensic Sciences. Again, this is a no vote required. This is an update. Commission members have been provided with a letter from Ascot Lab dated May 19th and the final surveillance report, surveillance visit dated May 19th as well. So again, this is for informational purposes. There's no vote required. Is there anyone here from Westchester?
I have a phone number for Bob Adamo if you have questions for him.
Hearing no questions, we're going to move on to Nassau County Office of Chief Medical Examiner, Division of Forensic Services. Similar situation, no vote required. For documentation purposes only, there are 2 documents for review: Ascot Labs letter dated May 20th and a final surveillance visit report dated May 20th. We have Dr. Buffalino from that lab here. Should there be any questions or concerns? All right. Hearing none, the next item on the agenda is the New York City Police Department. Similar situation, no vote required. We are looking at 2 letters from Ascot Labs dated September 2nd, 2013, and a final surveillance visit dated September 2nd, 2013, and then the surveillance visit September 2nd. So no vote required, purely for informational purposes. NYPD, under the accreditation updates.
It was sent out late, so you should have a copy. It's right here. Very.
Oh. Thank you.
Any questions for the New York City Police Department?
There's always questions for the New York City Police.
Anything you want to ask right now?
No.
All right, our next set of items on our agenda deal with laboratory disclosures. The first one is the Monroe County Crime Laboratory. John, are you there?
Yes. Yes, Commissioner, myself and Ellen Colhoun, the DNA technical leader, are here.
You want to give us a report on the disclosure?
On Wednesday, June 26th, I submitted a letter to the Office of Forensic Sciences notifying them that this corrective action involving this particular analyst was closed upon review and reanalysis of all her previous reported casework.
This was presented to the DNA subcommittee as well, I believe. Is that correct?
Yes. That's correct.
And what exactly was it that was performed in the way of re-examination or reanalysis?
For all 22 DNA cases that this particular analyst had analyzed, we would go back to the original retained evidence, re-extract, and take that through analysis. On those cases where there was no retained evidence available, we would go back as far as the DNA extracts and carry them all the way through analysis.
And that was done on all 22 cases?
Yes.
And what were the findings?
Results were concordant. There was no discrepancies.
I just have a question for you about the instrument plate setup. How was this discovered? Did you have a system in place that caught the discovery?
Yes, the controls did not perform as expected.
And that led to the discovery?
Yes.
Thank you.
Any other questions? Thank you.
That's pretty good.
You're welcome.
The next disclosure is the Nassau County Office of the Medical Examiner Toxicology Laboratory. We have a representative here.
Dr. Avila? Sorry, I didn't notice your QA manager. If you could introduce him also when you sit.
Sorry. Say again?
If you could just introduce your QA manager when you sit as well.
This is Tim Hahn. Tim Hahn.
This is the initial disclosure, I believe.
Yes.
Do you want to give us a report on it, please?
First, if I could just direct the Commissioner's attention to the letter that I sent to Mr. Gestream on the 27th. I inadvertently put some incorrect dates in there. The relevant dates would be the 16th, the 17th, and the 18th. I incorrectly put them as the 17th, 18th, and 19th. So beginning, say, on line 4, I believe it is, original reports were issued to user agencies on September 17. That should have been 16, and then the other dates follow from that point.
Thank you.
Okay. So essentially what happened was on September 16th, 2 laboratory reports were issued to the district attorney's office. There was an inquiry back from the district attorney's office. One of those reports that we issued on the 16th was a hospital sample which had an associated DWI sample, or a kit sample. What occurred at that point was the district attorney's office made an inquiry to us as to whether or not there was some legitimate reason why those 2 results, there seemed to be some discrepancy between the 2 of them. That's not terribly unusual. We have those kinds of correspondences. Sometimes the laboratory is questioned as to whether or not results make sense for a variety of reasons. Sometimes the laboratory makes inquiries back to the district attorney's office, for example. At that point, we asked the district attorney's office for some information relevant to the hospital samples. For instance, was there any record that blood products or any type of fluids were given in the hospital, which could explain that discrepancy? And they in turn asked us for information. We provided them with, we ultimately provided them with photographs of the samples themselves in an effort to check the provenance of the sample, so to speak. The following day, so we provided that information back to the district attorney's office on the 17th. That same day, I received a call from an additional person from the district attorney's office. My assumption at this point was that they had the information that we had asked them for. In other words, was any blood products given or something like that. Turned out that person had not been given that information up to that point. But by now, these 2 cases were on my desk. So following my conversation with that individual, I grabbed the DWI supervisor, and her and myself looked at the cases that were in question. At that point, we have ways of looking at to try and check some of these things. One is to see if there are any repeat analyses that were performed. Another would be we looked at what are known as PBTs, or presumptive breath tests. And what we were trying to do is match up and see if there were any issues on our end. We were able to narrow it down to 2 different runs that could be in question. One of the runs, we were able to determine that all of the information that we could gather showed that that run was correct, and that if there was some type of an error, it would have been with the second run, the samples that were ultimately sent on the 16th. Because in reviewing all of this data, it became, I had a strong suspicion that there was a problem. At that point, I notified the district attorney's office that there could be a problem and that we would be checking that the following day. In fact, we did check those cases the following day. They were retested. The retesting did show that there was a sample switch. Because we had notified the district attorney's office the previous day, they were able to stop those reports. They were never used in evidence. We issued amended reports, and then we began our investigation as to how this occurred and took whatever steps that we could have taken up to this point. So.
And you say the investigation of how this occurred, is it a root cause analysis?
Yes.
What's the status of that at this point?
We've made significant progress. We're completing some retesting at this point, but I feel strongly that we understand what occurred.
Dr. Avila, when you do a root cause analysis of some situation like this,
yes,
do you use a standard template that you've developed?
No, we don't have a template.
What is it that you do?
Well, I mean, I can describe what happened. Essentially, the first thing we did, not knowing at all what happened, and even if I had some inkling, I think the first most appropriate step to take was just simply shut down the analysis. This is what we did. We stopped any further analysis at that point from anyone in the laboratory. Because I have some, knowledge of how this testing is performed, there are really 2 areas that are of concern where this type of thing can occur. And I investigated those two areas, exactly. And we did that in 2 ways. One was, and this was prior to anyone, or as few people as possible knowing in the laboratory what had occurred, I interviewed everyone involved in the process. There were essentially at that point 4 people that were performing that particular test in that particular way. And I questioned them as to whether or not what their understanding of the procedure was in both of the areas in which I felt there could be an issue. Essentially, I got from all four of them the correct answer, so to speak, in what I'll refer to as the sequencing or placement onto the autosampler or the instrument. One of the individuals gave me a somewhat ambiguous or indicated that they may not religiously follow a particular part of the procedure in terms of when they set the samples up initially. It happened to be the individual that caused this particular error. Furthermore, we went and I had the DWI supervisor look at the autosampler on the instrument and check to see if that sequence of samples were still there. In fact, they weren't. They had been moved to another rack, but they were in the correct order. So it was in the rack. So, overwhelmingly, it seems likely that the error occurred during the initial sample setup. When I further questioned this individual and subsequently have spoken to this individual, she made it clear that, yes, there were certain times where she did not religiously follow the procedure that should have prevented this. So, many things have followed since that point. I mean, first of all, we initially took a look at all of her cases. This is a relatively new analyst. She did about roughly 30 cases. We looked at all of those 30 cases, and as I indicated, there are ways for us to sort of determine certain things about what happened. One is that there is a natural process of repeating samples just because there may be some type of QC criteria that's not met. It could be as simple as there's a power failure and the instrument stopped and everything had to be repeated.
Is there a computer backup for the samples?
The computers can be backed up, but not the instrument sometimes itself. There can be things that cause it, but I mean that's not something that we can determine that's easy. The instrument stops and that's not really an issue. So the way that we looked at her cases in particular were we looked at any of her cases that were repeated for any number of reasons. It so happens that because she did a relatively limited number of cases, and in one of her analytical runs she had 7 different cases, that particular run had to be repeated. So she had a relatively inordinate high percentage of her cases were repeated through this natural process. So, and all of those repeats made sense except for the 2 that we now know are an error. There is also, we can look again at presumptive breath tests and use that as some type of a guide to say, yes, the field testing indicated that this should be the level, at least within some reason, and her results made sense. We also had a number of cases in which there was, again, a hospital sample and an associated DWI sample, and there should be some agreement unless there's some, reasonable explanation. So we were pretty quickly able to determine that a great number, and I don't know, maybe 20 out of 30 or so, something like that, we could corroborate in some way. Ultimately, what we are doing now, and we've done to about 15, we're retesting all of her cases by another analyst, a supervisor in the laboratory. And we've done 15 of those, and so far we've found no issues.
Have you seen any need so far to change any of your procedures or protocols?
Yeah, I think it's important to say that had she followed the procedure correctly, this should not have happened. But yes, we changed, and even the area that I was suspicious of, but did not ultimately end up being a problem, we made a change there just to beef it up a little bit. But yes, we have made changes to the procedure, which I can give you a lot of detail.
I was just trying to really get the procedure you use.
Right. Okay. So, but and again, we also just in terms of making sure that looking at all of the analysts in the laboratory, we went back and pulled every case from 2012 and 2013. And again, through this process of, naturally we repeat a number of cases. We repeated about 11% of cases in 2012 and about 15% of cases to date in 2013. There, again, by looking at those repeats, which some are done by the original analyst, some of those would be done by a different analyst. There's no criteria that the same person does it, and we found no discrepancies.
Thank you very much.
With regard to this particular analyst, is there any training or any other steps that were taken or are being taken?
At this point, naturally, she's been removed from that analysis. The entire laboratory has been, because we have made procedural changes, we've had to retrain everyone and re-emphasize the importance of certain aspects of what we're doing. So the entire laboratory has been brought together and we've had a discussion. This particular person it has not been retrained on the new procedure because she's not doing it. We don't know what ultimately, where we're going to go in terms of her rehabilitation, so to speak. But certainly she would receive a full retraining prior to her replacement into any of that.
I also note, Dr. Veal, that your laboratory notified the defendants in this case, the defense attorneys.
I did not. That was a step taken by the district attorney's office. What I did do was verify that, that step was taken, not for my own purposes, but just because it was done, I wanted to make sure that I included it in the report. Yes.
Okay.
Just a couple of questions for you, Joe. So essentially, your root cause kind of puts it to a sample switch at the initial time on the instrument, correct?
Correct.
So is there a witnessing procedure now in place for those files to make sure that there's actually not,
Well, what we've done is we have the sample vials. You mentioned the placement onto the instrument. The sample vials are now being. They must remain on the instrument for review by a second analyst prior to as a part of the technical review. So they must remain on the auto sampler until someone else can go look at it and verify it. So the initial analyst verifies it, as they always had. We're now going to make sure that a second analyst walks over to the instrument and verifies that aspect.
They'll do that after the analysis, though? Or?
After the analysis.
Is it possible to do it before? Because then if there's a mix-up, you'd actually...
Well, the initial person is putting it on in the correct order. I don't see how...
Like at other labs I've worked at, what they have is they have a little sheet, and you walk over, you set it up, and then someone else will come over and verify, and they'll look at each order, you call it off, and they'll make sure they're in the right order. Because then what it does is it kicks it from down the line that you have that problem, where if there is a problem, then you have to rerun the sample.
Yeah, our step was to do it afterwards. I mean, that's what we were expecting to do. I mean, just in terms of flow in the laboratory, but I mean, I suppose it's something we can consider.
One other concern I have is obviously there's a mistake that was made, but to me, it's both an innocuous and an insidious mistake is one that can cause problems, but I also don't want someone's career ruined based on it. And I'm just concerned that this will cause someone to be completely isolated, so I just want to make sure that there's a path to bring the person back and have the right mechanism in place so that they can actually do what they need. So like after this procedure, your plan is to bring them back to this type of casework? Or?
Well, I think that the blood alcohol analysis in our laboratory is a unique analysis. It's the one area where the analyst signs the report solely. I mean, not without technical review, but they're actually signing the report. There are areas in the laboratory where this individual can work and does work, where her work is more fully reviewed, or she's not signing the report, and so she will be able to work in those areas. She, at this point, is not performing particular tests. I ultimately would like to see that happen. I have not made any decisions on that at this point.
I guess I just want to express my feeling that people make mistakes, and we'll try and figure out what caused those mistakes to occur, prevent those things from occurring, but I don't want someone's career being destroyed or devastated by one mistake that happens. Even if it is a problematic mistake, we have to try and get to the root cause, make the systems working better, and it's not the individual. Thank you.
Any other questions? Thank you for your report. Next, we get New York City Office of the Chief Medical Examiner, Department of Forensic Biology.
Hello, Commission. Good to see you again.
Good to see you. Thank you for coming. You want to give us a report on this disclosure?
Yes. This is a letter that we wrote to AskCloud Lab and copied this commission on August 7th. What happened was back in July of 2003, NDIS, the National DNA Index System, started a new auto search where they allow for a one mismatch. They did this across their entire NDIS database. 6 of those, or they found 166 candidate mismatches nationwide. 6 of those were attributed to our laboratory. We then started an investigation on what happened with those 6 candidate matches. We performed a root cause analysis Concurrently, we made contact with the ADA's offices to follow up on the impact of those 6 cases, and then we instituted corrective actions.
What were the corrective actions?
The corrective actions were, a lot of these mismatches occurred, or from cases that occurred years ago. So between 2007 and 2008, we eliminated handwritten CODIS forms, just because we knew that was a risk of misreading, and there was actually 2 profiles that were entered due to ambiguous handwriting. So that was one of the corrective actions. We also did our own local search, ELDIS search, using a 1 mismatch search stringency, and that occurred back in 2009. And finally, currently we're working on making no transcriptional steps from the instrument to the CODIS system. We're trying to get our LIMS to talk to CODIS, and we've been talking to the CODIS people all summer long about how to make that happen, so there would be no interim steps between the electronic data and the electronic numbers in CODIS. So those are the 3 corrective actions we're putting in place, or have put in place.
You reported here about what the impact was in the 6 cases, and I'm not sure I...
Well, we had just started to investigate that impact, or asked actually the ADA's offices to investigate that impact. We would not know, so we're reaching out to them, and we're still gathering information on that.
But what I didn't understand here is that you said on page 2 that 3 of the 6 cases reported a named suspect at the time of the crime. What do you mean by that?
So it wasn't an unknown hit. It wasn't. We didn't miss some sort of forensic unknown. What do they call it in CODIS? Not a blind hit.
What this sentence means is that 3 of the cases had a named suspect at the time the case came into the laboratory. So a suspect had been developed outside of DNA testing, outside of CODIS.
Right, but if I understand what happened here is that CODIS instituted a new rule that said when you're doing a high stringency search, instead of having every loci match, you should go back and look at instances where 1 doesn't, exactly, because there could be just these kinds of transcription issues, and they found 166 across the country and 6 in the city of New York.
Correct.
That's correct.
So what you're saying here, though, is that when you went to, for example, the Bronx, well, actually, you're saying 3 of the 6 cases, 1 in Kings, 1 of 2 in New York County, and 1 Queens. In those 3 cases, there was already a suspect developed by non-DNA evidence, right? But there was no hit to that individual because of the transcription error.
No.
No. So explain what you mean.
The matches were not to the named suspects. We're just saying that the cases already had named suspects, irregardless of the DNA profiles developed.
But you can't tell us now whether the profile that you have now developed actually matches those named suspects, right?
They did not.
They don't.
They did not.
We're still researching them, and this was a similar case.
So just to get that straight, in other words, now we know that the DNA profile obtained from probative crime scene evidence, right, is not from the person that had. Is that person, had any of those individuals been arrested or convicted?
Excuse me? Can I?
Had any of those individuals been arrested or convicted, to your knowledge?
The district attorney's offices are working on getting us that.
So that's what I understand. This letter is dated August 7th, so that's 2 months ago. Mm-hmm. And I assume that prior to August 7th, you'd already asked the district attorney's offices to give you a status report on the potential impact of those 6 cases.
That's correct.
Well, now it's 8 weeks later. How come?
Well, that information is trickling in, and we're actually preparing a follow-up to this I hope to have it out by the end of this month.
For all 6 cases?
For all 6 cases, yes.
You say one of the 6 cases was beyond the statute of limitations?
It was beyond the statute of limitations, I believe, before we even tested it.
It
Is
was,
that correct?
it was one of the sexual assault cases that was sent out as part of the New York City Backlog Project, and it was beyond the statute of limitations before it was even sent out for testing.
Who made the determination that it was beyond the statute of limitations?
The New York County District Attorney's Office.
Okay.
But, well, I guess the cases that are of greatest concern to me at this point, I guess, are the ones where there was somebody, now that I understand this correctly, that there was a suspect. You can't tell us as you sit here today whether that person had been arrested or convicted, but there was a named suspect. And now we know that that suspect is not the source of the DNA. And by the way, did this stuff come from like semen, or what was the probative biology that you were testing here in these cases? Do you know?
I would say at this point we don't know the actual probativeness of these
Well,
samples,
biology.
but these were items that were submitted.
I mean, these from sexual assault kits?
Some were homicide, at least one was a sexual assault kit. I believe
Four were homicides, 2 were sexual assaults.
Right. And I guess my concern is to make sure that both the court and any defense lawyer, if there is a defense lawyer, are notified, promptly as well, and that's something that should be built into this system. I know that and it's something I guess maybe the commission should take up, because in some ways it is not unlike the situation that we have in the system where there are DNA hits to cases where people have already been convicted or pled guilty, which was a conviction, and all of a sudden there is a hit to forensic samples which had not been sourced during the course of the investigation. It's my understanding that at least the New York County District Attorney's Office, and I think every District Attorney's Office in this city, because through the DNA hits program, they are notified at the same time as the police department of any hit, right? I'm looking at Ms. Mayers because I know that she attended some meetings with respect to this, but that is our comparatively unique methodology in the city of New York, that everybody is supposed to be notified of that kind of thing. And this, it seems to me, is even more important. I mean, ordinarily, in the hits to close cases where the district attorney is presumably going to investigate to see if it's something that's, if it's a cigarette butt that had nothing to do with the case, that's one thing. But this is different. Here we have people that are named.
And we followed the same procedure before the month of July was over. We notified the district attorney's offices and the NYPD.
Yeah.
So, just a quick question in regard to that. So obviously you're aware of the fact that the 2 new statutes regarding the OCME were passed and actually became effective a couple of days ago as law in New York City with respect to transparency in your reporting, your root cause analyses, not only to the prosecutors but also to institutional defenders, the city council, and other entities. You aware of that?
I'm aware of that.
So the question is, are you going to apply that somewhat retroactively in the sense that this is still part of an ongoing matter? For instance, you said you're still waiting to hear from the district attorneys regarding those 6 cases. Is it the OCME's intent to apply the new law that was enacted to this particular situation?
If this is still an ongoing situation, which it is, then we will apply that.
I can answer that question. The 2 laws that took root, that's the phrase I used at the end of last week. The transparency law goes into enactment 120 days after it takes root, and the root cause analysis takes root 180 days after enactment. We do intend, it is the choice of our acting chief medical examiner, Dr. Sampson, that we are going to be informing City Council of as much detail that we feel comfortable about these 6 cases. And what I mean by that is, the OCME can provide, in terms of our comfort level, very general information about the cases, but really any more detail about the specifics of the cases, particularly those cases that have ongoing investigations, that is entirely the province of the New York City Police Department and the District Attorney's offices to share that information. And we will be, the DNA Subcommittee, when we discussed this, I think 2 weeks ago, they asked for more general information about the 6 cases, and we're in the process of preparing a letter of reply, and we will be CCing the Commission on that letter to the DNA Subcommittee. But as far as the OCME, there are 2 cases here where a suspect who was originally identified, meaning, as our new director explained, identified outside of DNA. We know that there are 2 cases where persons were convicted, and we've relayed the DNA hit information to the District Attorney's office, and in one case, it's one of our local federal prosecutor's offices, and they will be relaying that information to the defense counsel.
Well, so I may
interrupt for 1 second. If we're going to have a big discussion, we should have her come to the table, because no one knows who she is. She's off the camera. I'm sorry.
That's a great idea.
If you can just bring up and just identify yourself. That sounds like it'll be more in-depth conversation. Thanks. Sorry. Sorry, Peter.
No. Appreciate it.
I'm Mimi Mayers. I'm an attorney at the medical examiner's office.
So, Ms. Mayers, just to, because I may not have been clear, I just want to know, I'm not asking you about the details of what you intend to do, because you said that the law will not go into effect, I think for one it's 120 days and the other is 180 days.
Correct.
Are you not going to apply that law to this particular situation, even in the spirit of the law, because technically the law hasn't gone into effect? Or do you intend to act in a way that would be in compliance with the mandates of that law as applied to this situation?
It's not something that we've discussed with our folks at the New York City Law Department, but it's certainly something that I can take back and discuss with our acting chief medical examiner. I'm not certain that the law department would advise a New York City agency to retrospectively be in compliance with legislation that's not in effect yet.
Well, I'm not talking about, for instance, cases going back 2 years or 3 years, but this is still a work in progress. The city council has spoken, it's become the law. And the law actually, as you said, goes into effect in 3 months or 4 months, but it is the law, and you're on notice of what the requirements of that law are. And I think there's a different situation between retroactively going back and looking at old matters from 2, 3, or 4 years ago and saying, wow, now we're on notice, this is what we were expected to do, and all the situations where we do an RCA. And even though this is still ongoing, because we might be able to wrap it up before the law itself goes into effect, we're not going to follow the law's procedures in this particular case. So I see a real sort of philosophical difference between those 2 situations. Perhaps you don't, but I think to the extent that that you decide not to apply the new laws to this particular situation, I would ask that OCME also communicate that to this commission, just what its position is going to be.
Okay.
Is that okay?
I'm not really clear on what you want us to communicate to the commission.
I'd like you to communicate to the commission whether or not you intend to apply the instructions directed at the OCME of what they're required to do in every situation where an RCA is appropriate or when it's conducted. It's very specifically laid out in statute. All I'm asking you is, after you confer with the Department of Law and whoever else you intend to confer with, if you would notify us as to whether or not you intend to apply the legal instructions that are in those 2 statutes, or specifically the one statute dealing with RCAs, to this particular instance involving these 6 cases.
And we will get back to you on that.
You'll get back to us on whether or not you'll even notify us?
No, we will of course, anything the commission asks us to get back to, we certainly will.
Okay.
As I understand it, Peter, you want to know whether or not The Office of Chief Medical Examiner will be, I think there are probably two provisions that may be on your mind. I don't mean to speak for that. It's whether or not we will be determining who the assigned counsel was or is on the two cases where someone was convicted, and whether or not we will proactively be reaching out and giving this notification to those assigned counsel, and whether or not we will be disseminating the root cause analysis on this NDIS 1 mismatch corrective action to all the persons that we're obliged to in the new legislation.
I'm not going to go toe-to-toe with you on the specific language of the statute because I don't recall it all offhand. I just want to know whether or not you're going to be in compliance with it, whatever it is. And if you're accurately stating what it is, then so be it.
Well, there's parts of the law, excuse me if I can interrupt, that we can't be in compliance of because it tells us how to do a root cause analysis.
I understand that. I understand that part of it, but I'm simply saying is with all the notification provisions and the transparency provisions. That's right.
Just to be clear, the transparency
Not
bill...
the transparency bill. The purposes in the notifications, which by their very nature of being notifications, makes that transparent. That's what I'm referring to.
Not to go toe-to-toe, but those notifications are embedded in the root cause analysis legislation, not in the transparency bill.
That's right.
As ironic as that
I
may
agree.
seem.
Right, but I think you're I don't want to say I recall the statute word for word. I do not, but I think that you summarized the gist of it. Just to put it in simple English, I'm concerned, and I think the legislation was designed to address a situation where something as serious as having a hit to a known person from probative biology, and presumptively it's probative biology, particularly if it's a rape, murder, or a sexual assault, should be known pretty quickly to somebody that might have been convicted, or is under charges in state or federal court. I mean, the reason the statute was passed is that they should get notification of any significant problem in the laboratory, but this goes beyond a significant problem. This is a hit to somebody, and so I think it would be a really good idea if you could inspire confidence in us that you would find a way to do that so that we could all be assured, because this is pretty eye-opening. To make sure that those lawyers are notified. Cool. I think that would really help in terms of one's attitude towards the laboratory at this point in time, to be blunt about it. That'd be a really positive sign,
Just quickly, this letter is dated August 7th. I'm just curious if there's been any conversations with investigators whether those two had consensual sex partners that might be the result of those hits, or has there been any investigation up to this point to see if they might be, hits for other reasons?
We're not aware of the details of the investigation.
Yeah, that's not their job.
Okay. Just following up on two quick other issues. I know at the DNA Subcommittee, they had raised two issues. I just wanted to bring them back. That apparently the one loci mismatch issue was also brought before the subcommittee back in 2009, and you were going to check and see, not that specific issue, but they had redone some of their hits and more were captured. I was just wondering if you had any time yet to look and see why these weren't captured during the 2009 analysis?
We are preparing that letter to the subcommittee, and that will also be out by the end of this month.
Okay, and the other issue was about the LIMS validation? About, because the LIMS is actually populating your coded software, so if there actually was a validation of that process.
There was a validation of that process. Yes.
Okay, thank you.
Okay. Any other questions? All right, thank you.
Next on the agenda is the New York City Police Department, who brought handouts. If you want to take one and pass around. So the NYPD's got a number of issues. I don't know. Do you want to take it in which way you want to go?
We'll do the handout first.
Okay.
That's okay. So this is a somewhat complex level 1 nonconformance that we had, and we felt that in order to illustrate what we did, rather than just talking through it, that if we put together some PowerPoint slides, it would help out. And we would have gotten this to you earlier, but we were literally still making changes this morning to try to make this as logical as possible. This had previously been covered in the executive session, so we're going to refer to the analyst as Jane Doe. Her identity we don't want to disclose. And the nonconformance and corrective action begin back in December of 2012. We'll get into the details of that. It's a level 1. It involves a criminalist and a latent print development unit. And the reason why we did things a little differently was we were concerned about our root cause analysis and the concept of root cause analysis, and wanted to try to formalize this as much as possible. So if we just kind of go to the page 2, second slide. So we're going to go through our root cause analysis tools, the root cause analysis process, in this case, and the corrective action specifics. This is actually, we didn't change that slide. So it goes 1, 3, 2. So if we cover the first thing on slide 4, which is the root cause analysis methodology. So we have a large laboratory, and we're always concerned that there's a tendency to default to operator error. So we're looking for something to kind of push us away from that, and then if we finally get to it, that's where we get to it. So we researched the literature, and we designed a methodology. This is kind of the first step. It's not necessarily the final step. So this is all subject to change. This is our initial approach, and we had to apply this methodology, even though we were already, through the corrective action, but we still wanted to try to get this done. So we looked at the ASCLD Lab International root cause analysis training that we received. It was a one-day training consisting of lectures, practice scenarios, small, large group exercises, hosted by DCJS, and members from laboratories across the state were there. We then looked at a second methodology from the Joint Commission. So this is a commission founded in 1951 that evaluates and accredits more than 20,000 healthcare organizations and programs in the United States. It's one of the nation's oldest and largest standard-setting accrediting bodies in healthcare. We went on to look at a paper that was done by a consulting company called Think Reliability. They work across a broad range of industries, and they specialize in root cause analysis, incident investigation, and problem solving. We looked at a British quality and safety certification program used by retail companies and suppliers. Usually the standards there focus on food safety, packaging, storage, distribution, and non-food consumer products. That's called the British Retail Consortium of Global Standards. So we don't purport that this is the end-all and the be-all, but we wanted to try to develop something that we could source back. And again, I don't want the Commission to think that this is it. So if we come upon something else, then we'll look at that. So in slide 6, we show you our root cause analysis process, which is, number 1, define the problem, data collection and data analysis, create an action plan, implement the action plan, and monitor the effectiveness. I'm going to let Scott discuss the tool that we created, and even as early as this morning, as we were going through this tool, we were talking about making some modifications. Scott, you want to discuss?
Yes. So as you understand, this corrective action started some time ago. So we were going through the root cause analysis. But as we came near the end in the last couple of months, we applied the methodology that the Chief just explained. But with that, we also created this corrective action report, a worksheet that allows us to make sure we try and hit all the bases. So as you see here, we have questions that we ask ourselves and prompts to make sure we don't focus on the human aspect, but focus on the process. So pages on the slides 7, 8, 9, 10, etc. are really this corrective action report, which we've actually implemented and we actually used not just with this corrective action, but also with the one we'll be discussing about the misplaced evidence. So it's something we feel has been very useful. We have a root cause analysis committee group meet. They come together, they use these prompts to discuss these issues. Like I said, it's really this tool that we've got now to make sure we try and approach each non-conformance of a level 1 we approach it in a systematic and structured way. So, like I said, pages 7, 8, on slide 8, sorry, you'll see it does talk about, I apologize, not slide 8. On slide 8, question 5, it does talk about personnel factors, boredom, inability to focus on tasks, personal problems. But again, that's just one question out of the series of 23 questions we devised to look at. As we go through slide 9, we talk about the equipment or the materials that may have affected the case, or environmental factors. Slide 10, we talk about other factors that could have affected it, such as technology or even communication in regards to procedures and policies. Slide 11 is just a blank sheet for us to fill in the information. Again, we're trying to keep the information in a structured format, a summary of the root cause, the action plan. And slide 12 is, of course, the aspect of monitoring the effectiveness of it. Are future occurrences of this event readily detectable, and how are new and current personnel made aware of this particular event? On slide 13, we discuss how has the corrective action been effective. So we set standards to monitor the effectiveness of the corrective action, and then follow up that with an audit of that particular corrective action. And then we just have an addendum.
So, if you go to, any questions? Or? So if you go to slide 15, we'll walk you through this particular corrective action and how we applied the process that you just looked at.
The first stage is to define the problem. So on slide 17, we defined the problem. During the technical review, the reviewer observed developed latent prints potential value on a photocopy of US currency, which were not reported by the examiner. Upon the investigation of this non-conformance, it was discovered that the same examiner did not report developed prints potential value on a variety of substrates. So that was us defining our problem. Slide 18, we get to, we're at that point of we're going to be beginning our data collection, point 2.8. But what we're going to do now is go into the specifics. This is this reorganization we did this morning. If you recall, there was 2 letters that were sent to the Commission describing the specifics of what occurred. The first letter describing the individual incident, and the second letter is a summary of what you're seeing today. We had an instance where an examiner did not observe 2 prints potential value on US currency that was detected upon technical review. So that's what is described in the initial case that caused us to define the problem on slide 20. On slide 21, at that time, the subject criminalist, the person that did the technical review, and the supervisor discussed why did you not report these initial prints potential value. Please note these reports were never issued. This report was never issued. This was caught upon our technical review process. The subject criminalist, Jane Doe, did not have an explanation why they did not observe these prints. And then what, upon being shown these prints, the subject criminalist, Jane Doe, didn't amend the report, issued a report because a report was never issued. So you don't amend a report that was never issued. So then a report was issued with these prints potentially value. On slide 22, it may be hard to see, but we're trying to show you the indicator. This was on the US currency. On slide 23, we zoomed in a little bit to try and show you the friction ridge detail that was observed upon the technical review.
And it was on a photocopy?
Yes. Because of US currency, you write the numbers of the US currency. So instead of writing the numbers, the examiner chose to take a photocopy of the US currency. So upon technical review, each person, you have to make sure that each page contains the lab number, it's paginated. So upon that review process, the person who did the technical review saw that there was these friction ridge detail.
I'll actually raise 2 questions. You sure that the fingerprint didn't come from the person putting it on the bill on the photocopy machine? But I'm assuming not. Can you really see the prints better on a photocopy than you can on the original item?
That's not the reason for doing that.
Right,
The
this
reason
is
for
just
doing that is
because
just
because
a
the evidence is
documentation
money.
method. That's it.
Yeah.
Right.
And if you look here also, they have the edges dog-eared. That's so they don't violate federal law because you can't photograph all of currency.
Yeah, I was
So you just get any ideas.
No, but I'm just sort of amazed that the way this all arose is that somebody saw it on a photocopy, not on the actual item.
Right, we have concerns, we had the Phyllis Martin case way back when, so we have heightened concerns regarding technical reviews in the latent print development unit. So it was picked up, and if you look at it, it is relatively patent. And if you compare what you have that you're seeing, if you're the technical reviewer, and you compare the notes, you immediately can kind of say, hey, why is this missing?
So slide 24 was our original definition of the non-conformance, that the technical review observed developed latent prints, potential value, and a full copy of US currency, which were not reported. So we created a cause map, which would help us to try and ascertain, to be upfront, this of course was done back then, and we're retroactively applying a structure to it. Twofold: one, to bring that structure to the corrective action procedure, but also to make sure we did not miss anything. So at that time, the developed prints of potential value were not reported. We deemed there was possibly two issues for that. One, maybe an issue with our procedure for porous substrates, and/or an issue with the examiner. And this was something that was discussed in the original letter that we sent back in 2012. So to deal with issue with porous substrates, we moved to cause map B. Did we allow sufficient time for the prints to be developed? Or, as you were saying, Commissioner, that maybe with the process of they were developed over time, and then when she photocopied them, they weren't there when she originally looked at the evidence. So at that time, we, based on statistical sampling, we recalled 28 vouchers. This included all the criminalists, and we worked in the latent print development unit with porous substrates, paper. And looking at all them, those 28, we re-examined the evidence, and the report and the substrate were in agreement in the number of prints potential value.
So consequently, the SOP that says, allow the print to cure, for lack of a better phrase, for X amount of time when you're using, these chemical processes, that didn't appear to be the problem because it hadn't manifested itself in the other cases. So our concern was we weren't allowing enough time for the chemicals to develop the prints, and that prematurely it was being examined. Now the substrate is placed aside, and there is more friction-rich skin being developed.
So moving to slide 28, we cross out that particular part of the cause map, and we move now back to the cause map A, where we're looking with potential issue with the examiner. Again, at that time we did a statistical sampling for 2011, and we recalled 26 vouchers. Prior to that, though, we found 5 of those 19 vouchers, the results were not in agreement. These results are all in the original letter we sent back in 2012. Slide 31 just describes the original report. 1A, as you see, the original report was 0 prints potential value. Upon re-examination, there was an additional 11 prints potential value detected. As you can see, there was non-porous and porous substrates.
And we were seeing the problem on both, which further verified or validated our feeling on that we were eliminating the process, the protocol, as being the issue, and it was now focusing more on Jane Doe.
So cause map C, as it goes through these different steps, it goes to the end step here at the moment of human error. On the right hand side, it goes to human error. At that time, we decided to expand the corrective action, looking at cases from January 2011 to March of 2012, focusing on cases where there were homicide, sexual assault, or investigate DOA, and prioritise any cases where there were 0 prints potential value in the original report. We also tried to identify any vouchers where possible testimony may have been given, and also we would do any re-examination of the evidence based upon any requests from the District Attorney's offices for upcoming trials. Up to this point, everything is in your original letter that we sent back in, I believe, May of 2012. The following is information that you would have seen in the second letter we just sent, I believe, in September. The total number of vouchers that we re-examined for Jane Doe were 143. Of those, 86 of them had charges of homicide, sexual assault, investigate DOA. based upon their original plan. 8 were based upon testimony that had previously been given. There were 30 re-examined based upon requests from the district attorney's offices due to upcoming trials. And of course there were 19 from that original recall where we detected those initial 5. Slide 35 shows you the results where 83% were in agreement, 17% were not in agreement. 24 of this, 24 vouchers had additional prints of value. On slide 36, this table is also in your letter. It reflects the original report. I'll bring you to line number 8. You'll see it says 0. Then re-examination, it says 11. This goes back to that original one we saw. These are the 24 that are listed. I've given you 3 examples that were listed in the letter. I've also put them into the presentation. Example A was this 0 to 11 of a plastic bag. Slide 38 reflects 3 images of those 11. Example B was in regards to a broken knife handle. What I'd like to point out to you on slide 40, there's 2 arrows, I'm sorry about the colour, but on the left hand side, the handle of the knife, the original analyst developed a print on that dark substrate, which would have took sufficient time and effort to do so. This was not of like, let's just do it. This is significant time and effort to do so. However, on the arrow pointed on the blade of the knife, which I then on slide 41, if you try to zoom in on, you see possible blood or friction ridge detail that the examiner did not report in their laboratory report. In that particular same case, there was another example of a similar instance. I could ask you to jump to slide 44, and looking at slide 44, you may see this metric card with an arrow pointed to the blade, the edge. That was actually done by Jane Doe. Jane Doe is actually pointing to an area that she'll be conducting swabbing, but there's actually friction ridge detail there that she did not report in the laboratory report. But again, in that same case, there was a knife where there's a print on a handle that requires significant time and effort to try and develop.
So we saw no indication that there was any kind of cover-up. So, Phyllis Martin, the issue was it was there and I'm not going to photograph it. Here, it's there and difficult friction-ridge skin is being photographed, and in this case, this particular, on slide 44, this friction-ridge skin is inadvertently being pointed to, and yet it's not being picked up. When I say inadvertently, what I mean by that is the purpose of the analyst's initials and putting the measure there is not, the rule has got nothing to do with that print. So we weren't seeing any kind of intentional conduct, and I know at previous disclosures when we were in executive session, we discussed that fact, that we weren't seeing intentional conduct. We were somewhat at a loss to try to figure out how the heck did this happen.
The third example is regard to beer bottles, and the purpose of this was to show that, again, the examiner originally reported a print potential value, and then there was a print no more than maybe an inch or 2 away from that same area where they did not report it. So those are the 3 examples. Over the past 22 months, we've had 2 Crim Force supervisors dedicated towards moving forward with corrective action. We've had 3 criminalists involved, full-time and part-time. We've had technical reviewer. We have, of course, EMS control personnel in regards to obtaining the evidence from storage locations. Quality assurance, we have 2 criminalists who've been mostly dedicated to this particular corrective action, specifically more so in the last 6 months. We've been trying to formalise everything rather than the way we've been doing it before. And of course, for myself and key management personnel in the laboratory, and also from the executives within the NYPD. So, if you recall, I showed you like I said, the colour wheel. It's not colour here, but investigating the root cause. So we're at 2A, our data collection. What was our data collection? Well, first was our re-examination of the 28 vouchers of porous substrates that were from the other examiners in the Waiting Print Development Unit that allowed us to rule out that being part of our root cause. We re-examined 143 vouchers. We reviewed literature. We reviewed our SOPs. We interviewed the subject matter criminalist, Jane Doe, initially, and based upon her initial comments, she was unable to come up with a reason why she did not report those original prints' potential value. We also met, of course, with other members in the latent print development unit to understand the processes. We had members of quality assurance do case observations, watch people go through a case to try and understand the steps that are taken. And also, when we sent members of the laboratory to IAI, we tried to meet with other experts in the field to understand if they ever had a similar issue in regards to this thing of misprints. Unfortunately, they did not. So, investigating the root cause, we have the causal factors, and they're listed here 1 to 5. These 1 to 5 reflect that worksheet I'd shown you before, those 23 questions. They're carried over in there. But the next step also to do is to do the 5 whys, which...
I'm sorry, just a quick question.
Sure.
You say there were 5 causal factors. You found all 5 of these to be...
No, I'm sorry.
No,
these 5 causal factors... Considered.
Okay.
These 5 causal factors, if you go back to that worksheet, you'll see them, they're sprinkled throughout that worksheet.
Okay.
No, they're considered.
And then within the 5 major categories, then we try to bust out all the, subdivide all the, to keep asking questions to try to not stay focused on one thing, but keep kind of challenging the initial.
So again, based upon the literature review we've done, but they talk about the 5 whys, and the reason of the 5 whys is to make sure that you don't stop. They talk about weeds, like when the root cause, just don't try and remove the weed, you move the root of the weed. So that's why you keep asking these 5 questions. They feel it's not like a magic number, but it's a number they feel you should be asking. So as you see, you read from top to bottom. As our first, we define the problem, and you say to yourselves, why? Well, because. Why did this happen? Because developed prints' potential value were not reported. Why? Because the examiner did not observe the developed prints or did not recall that the prints were present at the time the report was generated. Why? Because human error. Why? Because the standard operating procedures did not include the marking of the substrates and the documentations of areas of friction ridge detail in the notes. Why? Because the standard operating procedures relied upon the examiner's discretion.
So what this shows is not why Jane Doe was missing this. We still don't know. We don't believe that there was any malfeasance. So what these whys are telling us is how do we put something into place systematically to try to prevent this, understanding that we still have to do casework, and we got a lot of it. So we tried to find a balance between ways to prevent this from catching this if it should happen without shutting the laboratory down and doing one latent print case a year.
So the next step, as you see in the color wheel, is to create an action plan. So in regards to the subject criminalist, that individual is deauthorized to perform casework and has continued to perform an administrative assignment that is critical in the laboratory. The second part of the action plan is to supply to the customer all of the cases the subject criminals, Jane Doe, had performed in their career. We were able to compile a database with much time and effort of 3,326 vouchers, as much information that we could ascertain, and we have supplied that to our customer working group.
So specifically, the detectives from part of my technical support unit had to now go into our arrest database and complaint report database to try to associate these property clerk invoices, the vouchered evidence, with some other NYPD report, so we could try to figure out what is this. This is a very, very difficult step. So a lot of, Scott mentioned earlier, the resources, a ton of resources were put into this. This list now was circulated to the 5 district attorneys, the Corporation Counsel Family Court Division, to take a look at to see are there any cases that they have an issue with, and they were also obviously circulated to me as the Chief of Detectives and the NYPD rep to see if any of these cases were generating issues from an investigative standpoint.
The third part of the action plan was to enhance our standard operating procedures, mandate the marking of evidence on substrate, and document in the notes the number of friction ridge details, and also include a step called final confirmation and full confirmation. I prefer to get to that point later in the slides to explain it, because it means you can read it at that time. So that was our action plan. The fourth part of our root cause analysis process is to implement the action plan and monitor the effectiveness. The evidence marking, the final confirmation and full confirmation, which I will get to what those steps are, have been used by the latent print examiners since last year. It's been almost a year we've been utilising, because this process has been long. We didn't wait to the end to implement what we thought would be beneficial. As of this time, as of the beginning of this month, and as of today, because nothing has came to my attention, there has been no additional reports reviewed in which latent prints have not been observed, have been observed but not reported. So that's us monitoring our effectiveness. What I'd like to talk to you about is our current procedures.
So is that with her?
It's for the entire unit. The entire unit. I'm sorry. This action plan and monitor effectiveness was in regards to the implementation that we've placed in the latent print development unit, where we have a number of examiners.
The corrective action with respect to Jane Doe was to take her out of the latent print
Period.
development
That's the end of it.
That's the end
Yes.
of it.
Right.
But now we have to make
No,
sure.
I understand that. Okay, finish your presentation. I apologize. I'll ask you.
So, the latent print development unit procedures as of today are evidence marking 100% of all vouchers. So 100% of all submissions, the analysts have to mark the substrate and document the total number of areas of friction ridge detail in their notes. There is what we call a final confirmation. That's 100% of all vouchers, 100% of all laboratory reports, where a second examiner will review the original examiner's work after the final step of the examination process and will physically examine the substrate. So the substrate, 100%, will be physically examined. The third is what's called full confirmation, where 6 vouchers or 20%, where a second reviewer reviews the original examiner's work after each step of the process. I am not a latent print examiner, but there's many stages to a particular process where they apply particular chemical dyes, stains, where they may develop a print may be washed off, another print may be developed. So 20% or 6 vouchers for each of those examiners, where the second examiner review the substrate. And we have photography review, which is a second examiner reviews all photographs of friction ridge detail, which will be submitted in the laboratory report to the latent print section. As we've had in the past, we have 100% administrative and technical reviews, and we've also included a supervisor evidence review, which is once per year, where we have a full confirmation, we have a final confirmation, and we're going to pull a case once a year where we're going to re-examine it per examiner.
I'm just curious, at these different stages, do you have any data on how many additional prints are found on the second check or the third check? Am I making this up?
So if you, let's say, take a porous substrate and you, I don't know if DFO is still used, but you might use an alternate light source, which is non-destructive. So whatever's there is going to be there. Now use DFO. The DFO may develop prints that weren't there, but knock out some of the prints that you saw on using the forensic light source. If you go move to the next step of anhydrine, you may develop additional prints, but you may either cover or knock out prints that were developed using the DFO. If you go down to a third step, physical developer, or whatever the third step might be, same thing. So what we're trying to do is have another analyst take a look at what's going on between each step, because you can't wait till the last step.
Right.
Things may have been lost that should have been photographed along the process route.
My question is, when you get that second analyst to come in at each of those different stages, are they catching a significant number of prints that were missed the first time? Do you keep track of that data? I'm just curious.
I don't have track of that data. The supervisor in that unit meets with the examiners and discusses that whole procedure and policy with them, and none of came to my attention where it's something where we're talking of misprints, where someone's not marking a substrate entirely. You know, I mean, these are three-dimensional objects, as you know, and we don't want to make it into like, you know, if you don't catch something, you're done. But they are meeting regularly with it, and everyone understands the importance of marking. I think the big thing is marking, because as you know, as someone's saying, like I wasn't marking before. So here's a print, here's a print, here's a... Okay, I've lost myself. So by marking, we think that's a big part of what's going to save what happened this originally. That the examiner may have assumed that, okay, I've captured everything, and they're not going to look at it again. But by marking it forces you to go back. My notes say 8, but I have 8 marks.
Which again doesn't address the
human error.
The also developing prints in between the processes, because you can't mark something when it's still in the process of being developed.
But her notes didn't reflect all 8.
Correct. Yeah, because it wasn't mandated to put in the notes areas of friction-rich detail.
So that aspect of the problem is not a marking issue, it's something else.
It was a recording, documentation issue.
Or even,
wasn't
or
her
even
problem.
observing. She may have even failed to observe the...
That's possible, but we don't know because we didn't mandate that this be captured in the notes.
So, 2 things. One is, first of all, I think you really should be commended because I think this is a great sort of thought experiment, too. To go back and do this analysis, thinking about what are some of the best attributes of a root cause analysis, and then apply it retroactively to something you already did is sort of it's a very difficult undertaking, and you did it quite well. So that's terrific, and we really appreciate that. The only question I have is that when you decide that it's human error, and it looks very, very clear, that wasn't intentional, excuse me. Yeah. It's not intentional, it's not reckless. She's not doing it right, okay? We don't know whether or not she's failing to observe or whether she's observing and failing to document. How do you then get to that second answer in the root cause when you say it's the failure to mandate marking? Okay, what is the thought process that you relied upon that determined that had there been a mandating of marking, this problem would have been avoided? That's the only thing I'm missing.
Yeah. Well, it's not necessarily, and Scott, you correct me if I'm wrong, it's not necessarily avoided, but it would have been caught faster. So perhaps it could have avoided the problem by kind of compelling the analyst to take a closer look. So the inattention, which is the word we're using at this point, that created the problem could have possibly, don't know, been rectified with the marking. If they were marking and it's not marked, now the question becomes, well, is that inattention or you just didn't feel like doing it? But who would take the chance? I guess there are people who would take the chance. If we go back, unfortunately, to some of our previous corrective actions. So there's no foolproof way to have avoided this necessarily. We're kind of doing the best we can, and within the constraints of having to run a very large laboratory with a huge caseload. So we're trying to find the middle ground, and that's why the root cause analysis, this kind of more formalized process, is helpful, because we have to make sure when we report this up to the police commissioner and to you, that we have a basis for our decisions. That, it's nice to have come to the correct conclusion, but we're really trying desperately to get a process to get to the correct conclusion, because if you have a good process, over time you will come to more correct conclusions than not. You can come to the correct conclusion, have no process, but I don't know how you're going to do over time. So that's the reason why we're trying to adopt a process. And this is not perfect, and it may be subject to change, but it's our kind of first shot at it.
Okay, if there's no other questions on that, I believe you've got more stuff in the hopper, right?
Yeah, unfortunately.
A letter dated September 13th, it was sent to the Commission in regard of evidence that was accidentally discarded into the garbage of the police laboratory. We're currently in the process of finalising that root cause. We followed that process we just showed. We put a committee together. That committee answered those questions. I don't have the final root cause. I'll probably supply a letter to you by the end of the month. But one is steps that we have taken is We did have a dozen people searching through a sanitation truck for 2 hours to try and recover this evidence. Thankfully, they were uniformed, so there was no problems with the union. But they did a great job in recovering the evidence. From our aspect was...
So we did recover the evidence.
We did recover the evidence.
We did recover the evidence.
And much more, I'm sure.
It would appear, and I will cover this in the letter, but it would appear that one of the root causes was that as a convenience container for a paper substrate, this was the convenience container was craft paper, which is often used as a barrier between the bench and the evidence, where the examiner accidentally threw it into the garbage. So at the moment we have placed lime green stickers on that evidence, that craft paper, and we're in the process of purchasing a different coloured craft paper that will be used for convenience containers. We're also looking at our procedures, and we're going through those 23 questions to see what the root cause, rather than just say, well, the examiner threw it out. No, there is a reason we're trying to determine.
Right. And using kind of the healthcare model to a degree, we've seen cases where there's a difference between blood and it's blue, but one is light blue, one is dark blue, and so very well-meaning people grab the wrong blue, thereby giving the wrong thing to the patient. So we're trying to kind of bring everything from different aspects of quality assurance to bring to bear on this.
Did you know that sanitation kept records of which trucks go where? Were you able to recover that?
Yes, what happened was we had just missed the pickup. We had missed it. The pickup was on time. So we called sanitation and we identified the vehicle, and the vehicle came back from the route to a sanitation depot near the laboratory, where we sent the individuals.
Right. Plus, we know this from dead body cases. Yeah. So when we're hunting for a dead body in a dump,
which trucks might.
Well, when it's the our sanitation, meaning the New York City sanitation, it's very well kept. But when you're now dealing with private carding, it can get a little dicey, and as time progresses, the private carding, they change hands, records move. So unfortunately, in the Detective Bureau, we have a lot of experience tracking down refuse to try to figure out where might a body be in a particular area of a dump. But even in the dump, you can get it narrowed down, unfortunately, to a very huge area, but it's not the entire dump.
All right, 2 down, 2 to go.
The third one is a letter dated July 19th. This is regards to a 1992 firearms examiner. This originally started in a letter that was sent to the Commission on May 11th of 2012. To bring you up to speed on that, it was in regards to a case where we believed our preliminary root cause was that it was a transcription error by the examiner in 1992, where the firearm was a right 6, where he had documented right 8 or vice versa. I can't remember the details, but right or vice versa. So R6, R8. Based upon that, we tried to obtain that individual's testimony for that particular case, and based upon discussions with our customer working group, we decided to do a statistical sampling. That information now is in your second letter that we sent in July of this year. In that second letter, we're making assumptions, but based upon the testimony that was given, it would appear that the individual used the words incompatible, which leads us to believe it is more to do with a transcription error of saying, well, I have R6 here, I have a firearm, it's R8, they're out.
Without actually doing the examination.
Without doing the examination. However, we continue to form our statistical sampling of the cases, which was based upon the caseload of 578 microscopic examinations that we could find in the laboratory that individual conducted that year. We recalled 28 reports of that evidence. 20 of 7 of those were in agreement, and 1 of them was not in agreement. The details are here, but the gist of it is that the original examiner in 1992 said that 4 bullets were fired from 3 firearms, whatever breakdown that is. Upon re-examination, our firearms examiner saw class characteristics and saw some individual characteristics, but their determination was inconclusive.
So it wasn't out, but it wasn't in, when we did the, the current, under the current procedures and training, so they didn't mark it out. So we don't know why Detective Natali back in 1991 marked it in, but for whatever, at least it wasn't out. So in terms of error, it shouldn't have happened, but it wasn't the opposite, so we were inconclusive.
But except I only pick on one little point, which is that going from inclusion to inconclusive could have the same effect as going from inclusion to exclusion.
Absolutely. But in terms of us trying to recreate what was going on in 1991, in versus out would, I think, be worse, although I don't know that anything's better, but we can't reconstruct what happened in 1991. It was not an accredited laboratory in 1991. So we're not trying to minimize, the impact, but just trying to, put it in context. Context is a better word.
Last but not least, Glenmore.
Yeah, the police laboratory is a facility in Brooklyn where we move our case record storage. That was unfortunately flooded on, I'm sorry if I had the date here. It was flooded early this year. The date's not readily available to me. It was flooded early this year. Based upon there was 12 inches of water. Now, this location was verified on the day of Hurricane Sandy, and there was no flooding. So I don't want you to think, we did not check this location. We checked this location on the hour and during the time of Hurricane Sandy. The particular location, it would appear that 12 inches of water came into the facility and damaged a significant number of boxes where case record storage and also administrative records are kept. At this time, based upon the department is working with a vendor for Hurricane Sandy damage, where the vendor came to the facility 2 weeks ago and has taken all of the boxes, not just the ones that were water damaged. Based upon humidity and mold, they recommended that they handle all the boxes, and we agreed. And those boxes are now going to be, I believe, irradiated, stored, then scanned, and then we'll be given the physical evidence, the physical documents back with an electronic image of those documents that can be recovered.
So as part of our Hurricane Sandy remediation committee, where we're including the laboratory, even though they're not technically, actually not even close. It's an unknown leak. Where did this water come from? So we're using the Hurricane Sandy methodology to include the laboratory.
No other questions for the NYPD? Thank you.
Thank you.
New York State Police in Albany.
I'm going to take the garbage.
All right. So it looks like we have Major Monroe, Dr. Guzman, and Major Fawning cowering in the back. Okay. So you have 3 things for us, correct?
Yeah, I'll cover that. Yes, we do.
So is Dr. Guzman an update on the sperm identification corrective action?
So this is the previously reported negative sperm. We had discussed it, I think, at least 2 prior meetings, and it's just reporting the final closing of that. The reanalysis, which was the 4th phase of the project, is now complete. And again, we've determined that it was not a systematic problem within the laboratory.
And I might add that we have gotten a letter from Massclad Labs saying that they've decided that our corrective actions were appropriate and complete. And they're closing the review of the event.
Any questions on the corrective action? Okay, next one is the Mid-Hudson laboratory issue.
This is an incident of lost evidence. We determined back in May that the Mid-Hudson Crime Laboratory located in Newburgh, one of our satellite laboratories, misplaced one item of evidence consisting of heroin. So that's an ongoing personnel investigation at this point.
Okay.
I should tell you that we did notify the district attorney's office the next day about the fact that the evidence could not be located.
Okay, you said that's still ongoing?
Correct.
The last is the CODIS issue.
So that's CODIS hits on a number of cases that are related to cases that we have no longer retained the case file on. So when these were identified, we instituted a policy where we would be retaining the records indefinitely at this point.
Okay, any questions for the state police?
Yeah, I have a few questions. I'm not altogether sure I understand this. So, you got hits to forensic, to DNA profiles from forensic samples, right? How many years later, such that you discovered that you had destroyed what, the digital data, or your what had been destroyed?
The original case files. State police policy is that we maintain case records for 15 years, except for homicides, which are maintained on site indefinitely. And we're accumulating these old cases in CODIS, largely because of the All Crimes Bill, and we're starting to make hits to them now. This was sent to DCJS originally as a notification. We had a desired course of action, and we wanted to get that approval to start taking these cases out as these hits occur. And that's the INDIS recommendation. They want, since we can no longer support the hit, they want the profile removed from CODIS.
In other words, you're removing profiles from CODIS because under New York state law, after 15 years, you are not required to keep the actual case files. Therefore, the CODIS sample will be removed. The CODIS profile will be removed.
That's correct.
Well,
are these unsolved cases? What kinds of cases?
Sorry, just to back up 1 second, I'm not quite sure what the state law says.
I was going to say that I don't think that is a state law about. I don't believe. I will say. The law, I don't believe there's a law that says you have to get rid of the case files in 15 years. It was their policy. That's what they were doing. Right. I want to make that clear.
That's right.
Their own personal.
Right.
Well,
the retention policy.
Why do you have that policy? I mean, we're getting people out of prison consistently in this state 15, 20 years after they're convicted. Why are you destroying this after 15 years? And and they just discussed, they just solved the case. How many years old was that?
Are they talking about cases with
21 years.
Or cases with no arrest?
Yeah.
What difference?
Steve Hogan to join. He could talk about the state archive law, and the records are retained based on the state archive law by the state police. We have subsequently changed that, and we're just going to retain them indefinitely. These hits were all at least 15 years old. The 8 cases that are cited, we can go through and specifically detail those and talk about each case individually. The 2 cases that were actually a high stringency hit, that were cold hits, the DA's offices were notified in the police agencies, and the cases are beyond the statute of limitation according to the district attorney. 4 of the cases were low stringency hits, and it turned out that they did not match. The other 2 cases were high stringency hits that were actually they were forensic samples that were related to convicted offender samples, and the individuals that this hit occurred to were previously convicted of those instances. However, the offenses they were convicted of did not qualify them to go into the DNA data bank at that time.
Barry, I want to just say that I agree with you 110%. And I mentioned to Commissioner Green and to Gina and others that this is a sort of a structural issue of the right hand not knowing what the left hand is doing. In this day and age, these papers should be kept in perpetuity. There are answers to forensically relevant questions, and not being able to disposition these things because the paper isn't being retained shouldn't be acceptable. Our immediate fix is to hold them in perpetuity. But perhaps, a query at the state level as to what other people are doing you know, a permanent embargo. I think we're on exactly the same wavelength now. When this policy was instituted 35 years ago, we didn't have DNA data bank, nor did we know that well-preserved DNA could be so helpful. So I think we should all be moving in the direction of not having hits that have to be excised under these circumstances.
I think this. I think we should actually think about legislation on this point, and I think there's also some national standards about that have come about from some federal subcommittees that one of our policy analysts has been very active in, that set some standards for evidence preservation just generally, but certainly this archives law, I think we have to amend.
We don't have the ability to legislate, but certainly.
But we should recommend it.
Well, but
Well, Barry, you can actually, under existing law, you can file a modification. You can file, I forget the acronym, but you can file an acronym that says, I know you want us to hold these for 15 years, we're holding them permanently, and go fish. So we may not have to legislate it. We may be able to just send this RAJ notice or something. I don't pretend to be an expert on the education law, but it may not require that law be changed. There may be an administrative fix.
And I would suggest, I have two issues that came up that I thought of from this. The first is that I know the labs, when I was trying to formulate my lab policy, it was very hard to determine which law we were supposed to be following regarding record retention. I decided to keep them forever because I couldn't decide what I was supposed to do. I think if the commission wants to make recommendations to the laboratory for retention of case files, you know, at least as a start, at least to get the labs thinking about it and what you suggest, because I'm not sure it's clear to the labs what they should be doing. And secondly, I have an issue with, I think we need to, DCJS should notify all of the laboratories about this other rule, because until I heard about this, I was not aware that if the records were destroyed that the profile needed to be pulled from CODIS. I don't know if the other labs are or not, but it's possible that other labs have similar record destruction policies and still have profiles in CODIS that, according to what you're telling us, NDIS is requiring those get pulled out.
There's a CODIS users meeting Thursday, Friday this week. It's going to be addressed.
That was a recommendation from Doug Harrow at NDIS, and but I could see where these might be still retained at Estes.
And that was going to be my question, that maybe we should set policy for what we want to do here in the state about that.
A uniform policy.
Right, but I think that whatever can be done to issue regulations in the short run to retain the evidence just as the state has done, I think that I would commend to your attention, Mike and Brian, as something that we ought to do. But then I think that we should actually, with the input from NICLAC, because you don't want to save everything in the world, but we really should have some uniform state law that gives real guidance to laboratories and everybody else about what should be saved.
And again, the funding issue, don't forget.
We have our own policy. Probably show it to you.
Right, well,
but also, and I know I bring this up all the time, but the issue I face is, there's only so much space we have.
Right.
Everything now is off-site. I mean, somebody's going to be paying for storing those records forever, so we need to think about that as well.
The one thing that NDIS did say that I wanted to make sure we included is the fact that they're only asking us to remove these as these hits occur. They're not asking us to go back and retrospectively sift through these files and decide which ones have been thrown out or not. So what we'd like to do, one of the things that we wanted to have come out of this meeting is that, yes, it's understood that we are going to take those out of NDIS, but as far as I know, we can retain them at least for the time being at Estes.
Well, is this, it's not federal law, it's just federal policy that they ask you to remove them, right?
He says it's in compliance with the QAS standards for us to remove them, to maintain compliance with the QAS standards, with the FBI standards.
Oh, so, in other words, they'll throw you out of NDIS if you don't remove these.
On the national level, not on the state level.
No, I understand, but that it seems ridiculous. But if
well, throwing us out of NDIS was never a discussion. Yeah. It was just basically, we would not be in compliance.
Yeah, we would get written up on a QAS audit and say you have to remove them.
Yeah, I know where you're coming from.
Yeah.
Okay. Other questions for the state police? Thank you, gentlemen.
Thank you.
Okay. Next issue is Onondaga Health Department Center of Forensic Science, an update on the firearms corrective action.
Okay, this is just a follow-up from the issue that was reported previously. We had a non-conforming work event, a previous examiner from before 2004. We had to reanalyze one of his cases, and we had one case where the new examination said a bullet was suitable for comparison, where the original examination said it was not. We had started a corrective action. We reviewed and decided we needed to recall 19 cases to reanalyze. That was back in March of 2013. The police department started sending some of those cases in. They trickled in from May till about August, and to date, 17 of the 19 cases have been submitted to us. This was just an update that I gave to ASCLAD because it had been 6 months since our first notification of March 2013. At the time I wrote this letter, we had redone 7 of the cases. One was the initial one, so really we had redone 6. 3 of those cases had results consistent with the original examination. 3 had results where the second examination felt that there were some class characteristics that could be identified, and also that they were suitable for comparison. Although I will point out, in all cases, they were not the best samples. It wasn't like the person was completely just missing it. It was issues where there were some individual characteristics that might be useful for comparison. We notified the district attorney's office of these results. They've reviewed the cases and determined in those 3 so far it was not an issue in the case itself. They also notified the defense in all of those situations. Even though it didn't affect the case, they notified the defense anyway. And at this point, we're still working the other cases. They're in process right now. We hope to have the ones that we have in the lab done by the end of this month. And we still are waiting on the 2 other cases. I've asked we're working with an arbitrator currently with the lab and the police department to try to get those cases brought to the lab. And I don't know why the other 2 haven't been brought, and we're still trying to find that out.
I'd just like to commend them for at least going to the level of efforts of trying to mediate with the customer, trying to get the stuff back. What a world.
It's a fun time.
Questions for Onondaga County?
Is the district attorney been helpful?
Yes.
Okay.
See what I have to put up with. March of 2013, we're still waiting for this. All this stuff could fit in the shoebox.
Okay, next issue, Suffolk County Crime Laboratory is 2 disclosures. First involving a 2009 corrective action. A gentleman from the laboratory here to discuss. We have the lab director, Bob Jenna, Don Dola, trace evidence supervisor, Joe Galdi, the biology supervisor. Gentlemen? Joe.
Okay, the corrective action involving the 2009 case, what had happened was 2 samples had been switched between 2 different cases. It was caught shortly after that, back in 2009, but the corrective action that was applied only caught the error in reference to one case. It did not catch it in reference to the second case. We are currently searching all of our samples using a quality assurance database, and as a result of that search, we caught that the second case had an error in it that had not been caught 4 years ago. As a result of that, we went back, checked the data. A corrected report was issued in that case.
Okay, questions? All right, the second issue involves some trace evidence of a paint chip. Mr. Dolan?
Back in March, it was discovered by an analyst that a paint fragment from a case that she was currently working on was missing. We did an investigation to determine if in fact it was missing. We searched the laboratories, every area that the analyst had been in while working on that item of evidence. It was determined that the most likely reason for the missing evidence was there was a work crew that was in the laboratory during non-work hours. The crew used a tarp to cover the workbenches at the time, and we searched to look for those tarps. They were not found. The garbage disposal company had come prior to the discovery of the missing evidence. And we have corrected this by creating a worksheet that involves notification of a section prior to work crews working in an area, specifically laying out what areas they're going to be working in, requirement that all evidence is removed from that location prior to the work, and lastly, that the individual that's responsible for monitoring the work crew is aware and cognizant of the fact that evidence needs to be out of those work areas prior to the work crew's work.
Hey, the evidence was left out, like on a bench overnight?
Yes, within the trace evidence section, correct.
Is there any thought to, is there a practical reason not to require the evidence to be put away, overnight, for example?
Yeah, we've had a lot of discussion about that through our last inspections over the years. Some of the evidence that we work on is very small, microscopic. We have decided our policy would be that as long as those items were sealed, they could remain out because the work areas are locked at night and there's no access to those areas. In this particular case, I was not notified of the work that was going to be done, and the analyst was not notified that there was going to be work on. Otherwise, the evidence would have been put away. So now we have in place a policy that enforces that the supervisor and the analyst, would be aware of that prior.
All right, so when you see evidence is left out, it's not that a paint chip, for example, is left out in the open on a lab bench. You're saying that it's sealed in an envelope, but that the sealed envelope could be left on the bench overnight?
That's correct.
All right. The policy does say, though, that it has to be sealed.
Yes.
All right.
And for further clarification, is this a general communal lab bench, or is this like an individual exam room?
This is within the trace evidence section. It's not communal. It's locked.
Okay.
It's in addition to the, the regular security system for the laboratory.
Thank you.
Other questions? All right, last lab disclosure. Westchester County Department of Labs and Research Forensic Toxicology Lab. Kathy, is Betsy Sprout available by phone? I didn't see her.
No,
I'm
representing her today. Chris
Outstanding.
Carding, I'm the QA manager.
Outstanding.
The disclosure, basically, during a quarterly audit of our QC charts, it was discovered that there was a point that was out of range. I investigated the run where this point was out of range, and I saw that a case had been reported. It was not bracketed by good QC. We immediately informed the DA's office. Earlier in that sequence, this case had been repeated. The earlier analysis was erroneously rejected, but it was actually good. We do our alcohol samples in duplicate. The numbers have to be within 5%. The analyst on the first sample assumed that they were greater than 5%, but didn't do the actual calculation. They were within our protocol. Those results were within good QC, so we issued an amended report with that acceptable number. The numbers didn't change very much. The second number was 0.34 alcohol, and the first number, which was acceptable, was 0.33. We had a training, and we stressed all the analysts. It's not just important to put the numbers in the QC charts correctly, but to verify that they're within the correct range. And we had all the analysts sign off that they were trained on that.
Any questions? No, thank you.
Thank you, sir.
All right, that takes care of our disclosures. For old business, we have the letter that, I think this was at Dr. Jenny's request, it was sent to ABFT regarding the New York City OCME inspection report. We got the response. I don't know if there's any discussion on that.
There is one comment I'd like to just put on the record. I did email Dr. Jenny the ABFT response, and he did correspond by email back with me that he is okay with it, and he thought, I can try and find his exact wording, but he thought it was okay to proceed to a vote. I'll give you his exact wording in 1 second. Before my email crashed. But there is a correspondence back from ABFT that was received yesterday, so I apologize that it sorry. I see no reason to delay the continued accreditation of the OCME Toxicology Laboratory. So I'd recommend, in light of Dr. Jenny's response back, that I would ask, if there's no questions for Dr. Stajic or of the documents reviewed, I would actually like to make a motion to vote, because if you recall, we provided an accreditation for OCME Tox just till December, just pending the resolution of these outstanding issues. So I'm not sure if there's additional questions.
Can I give a motion?
Yeah, I'd like to make a motion to extend the accreditation period for the New York State accreditation for the Office of Chief Medical Examiner Forensic Toxicology Laboratory to mirror the ABFT accreditation.
Do you have a second?
Second.
All in favor? Well, do we have any discussion? All right, all in favor? Anyone opposed?
I'll abstain.
Okay. Any other abstentions?
Okay.
That brings us to new business. The first matter is just is a matter of information for all the commission members. I believe the section 74 of the Public Officers Law with a memo was sent to all the commission members. The second issue we have under new business is a letter that we received dated September 18th, 2013 from the Suffolk County Crime Lab Director, Jenna, that's been circulated to the commission members. I believe Director Jenna is here and wanted to comment. Is that right?
Yes. Left is Bob Biancavella with the District Attorney's Office. For the record, I'd like to read this letter out loud, and then I have a short comment. This correspondence to you, Commissioner Green, is to inform you and all commission members of an upcoming presentation to be given by Commissioner Member Marvin Schechner. This presentation to the Suffolk County Criminal Bar Association is scheduled to be given on October 24th, 2013 at a local restaurant in Suffolk County. The presentation is titled Trouble in River City. The Suffolk County Crime Lab is accredited and why the defense bar and the public should be afraid. It concerns me professionally that a member of the Forensic Commission will be presenting on a subject matter specifically aimed at a local municipal forensic laboratory in New York State. It also concerns me that this member will be presenting his opinions and not publicly state this fact, and that might be misconstrued as the opinions of the entire commission. I am also apprehensive that permitting this type of behavior would ultimately have a negative impact on the sensitive working relationship that currently exists between the municipal forensic laboratories and analysts in New York State and the Commission of Forensic Science. I ask that the commission members be made aware of this presentation. When a commission member intends to publicly criticize the Suffolk County Crime Laboratory or any other municipal forensic laboratory, it needs to be addressed by this commission. Here is an individual who has already publicly accused our laboratory of wrongful convictions. Then a few minutes afterwards, when questioned about his comment, publicly denies the statement. I ask everyone in this room to view the videotape of June 26, 2013 to confirm what I'm saying. What he is doing regarding this presentation is inappropriate for his position, appears to be in violation of the Public Offense Law number 74, is unprofessional and unethical. It is the opinion of the Suffolk County Crime Laboratory that this individual should be removed from the commission due to a lack of trust and his abuse of his position on this commission. The commission members should carefully review, the commission members should carefully review the action of this individual with respect to the Suffolk County Crime Lab by conducting its own investigation and then make the obvious decision. Thank you, sir.
Is there anything that the DA's office wanted to add?
Yes, Commission members, I'd just like to make you aware of the practical effect, well, not the practical effect, the effect of a communication that was sent to this commission by Mr. Schechter prior to your accreditation of the Suffolk County Crime Laboratory. And it came up in the context of a murder trial that I was trying earlier this year. It was a triple homicide involving 2 juries, 2 defendants, and several members of the Suffolk County Crime Laboratory testified as experts in this particular case. At one point during the trial, one of the defense attorneys attempted to cross-examine Dan Cheswick from the DNA laboratory using the letter that Mr. Schechter had submitted to the commission regarding his disapproval or with this commission's accreditation of the Suffolk County Crime Laboratory. And the attorney represented to the court that this document was a finding of a member of the Forensic Science Commission, and therefore he should be permitted to cross-examine Mr. Cheswick with respect to its particular comments. Now, obviously, I objected, and an inquiry was made by the court regarding the specifics of the letter. And the court was smart enough to realize from the outset that the Suffolk County Crime Laboratory had been, in fact, accredited, and that this was just the opinion of one of its members, and really had no place within the context of this particular trial. But my concern is this. I'm the Deputy Chief of the Homicide Bureau in Suffolk County, and I've been doing this in Nassau County and Suffolk County for nearly 30 years. Nobody supports the education of attorneys in the area of forensic science more than I do, whether it be the prosecutors or defense bar. I think the training is wholly inadequate. This, I believe, it goes beyond that. And as a representative of the bar and as a member of the bar, I don't think this is about training. This body specifically found that the Suffolk County Crime Laboratory should be accredited. Mr. Schechter does not agree with your finding. Well, as a member of the Forensic Science Commission, he can voice that opinion within the committee. To take that opinion outside of the committee and start presenting it to defense bars as a member of the Forensic Science Committee is inappropriate, and I believe is out of line. I've had a lot of experience cross-examining defense experts, prosecution experts, and I've had a lot of experience with the members of the Suffolk County Crime Laboratory. I don't believe on any occasion I have ever heard one of them render an opinion that we went beyond the limitations of their particular discipline. I don't know what Mr. Schechter's experience is in Suffolk County. I don't know whether he's cross-examined any of our experts from the crime laboratory. I don't even know whether he's even reviewed a transcript of one of our experts' testimony during any of our criminal procedures. So to come out there and educate the defense bar on how to properly cross-examine a prosecution expert, I'm all for it. But to come out there and essentially represent to the defense bar that he is a member of the Forensic Science Commission, and I disagreed with the accreditation of the Suffolk County Crime Laboratory, I believe that's completely out of line. And essentially, by advertising this program under the guise of there's trouble in River City, you know, I think is inappropriate.
Bob, you look pretty good, by the way. I think you've lost weight.
Thank you very much.
I just have a question or two. In any, I'm not familiar with any of the advertising. I haven't seen any of it, but in any advertising you're familiar with, either anything you've seen in writing or anything that's been put out publicly, have you seen or heard, or are you aware of anything that identifies Marvin Schechter as a member of the Forensic Science Commission in connection with this presentation?
There was a flyer distributed. I don't happen to have it with me, and I didn't pay that particular attention. I just saw the name and I saw the title of the program.
But you don't know anything. I think one of the problems I have here is that you could be anticipating what you believe to be the substance of the lecture before hearing it.
Again, Mr. Schechter, just from the title of...
From the title, I
from
can
the title.
understand why, but let me put it to you this way, and see
How
if
does
you have a
somebody-
problem.
how
See,
does
you have a
somebody-
problem with it. Just because a lab is accredited, right, that doesn't mean that all the work that comes out of a laboratory is going to be correct, or indeed should not be subject to vigorous cross-examination and testing in court. I'm sure you agree with that.
I agree with you 100%.
One of the things that happens very frequently, and you've got to remember that we've been on this commission from the beginning, right? You know,
I know you have.
Is that we see quite a number of corrective actions taken, disclosures made, things are corrected, and then the lab is accredited, or even provisionally accredited, and then one of the things that this commission has been criticized for doing by the Inspector General, right, with respect to the Nassau lab, and I know you were for many years in Nassau, is that that the defense bar, just as in many instances the prosecution, are not always aware of the substance and the details of things that go on in this commission. Now, I'm sure you have no problem here that anything that is a matter of public record that's discussed in this commission is a matter of public record, that a defense attorney or anybody else has a right to bring it up in court one way or the other, if it is relevant in the case. It sounds like in this instance an effort was made to take a letter that Commissioner Schechter had written and to use it to impeach a witness in an improper way, insofar as this is a finding.
Accreditation of the laboratory.
Well,
that's what it was being offered for.
Barry, just for clarification, that letter never made the open public web. I don't believe that letter was there. So
that was my second concern.
It's not something that was downloaded off the web that was provided the night before the meeting. That was one of, remember, I believe that was the letter that was provided, so that, there was no way for it to meet that deadline when everyone was in New York City for the meeting.
May I read what the presentation is going to be presented, which is on the website. This presentation will be invaluable to any attorney practicing in Suffolk County. Why? Because Mr. Schechter will report on the recent accreditation of the Suffolk County Crime Laboratory by the American Society of Crime Laboratory Directors Laboratory Accreditation Board and the New York State Commission of Forensic Science, and the problems discovered at the Suffolk County Crime Laboratory during the accreditation process, what explanations were offered by the Suffolk County Crime Laboratory leadership for the problems, what these problems mean for the criminal defense practitioner in dealing with the lab and courtroom forensic science problems, and what needs to be done and how discovery can be improved. This seems inappropriate.
I'm sorry.
This is wrong.
I just
I'm
have a
not done
question.
yet.
No.
Please, give me...
I just have a question of you.
All right, but I'm not done yet. This is wrong. It's inappropriate. I mean, you have right situations and you have wrong situations. This is wrong. It shouldn't occur.
Okay, my question is, only because I don't know the whole history of this, but I do know a little bit about the suggestions of prior restraints, of the First Amendment, of people, just let me finish, of people who are members of this commission who nevertheless can go to other forums and give their opinion, as long as they are not referring to matters of confidentially gleaned information. So the discussions about accreditation of laboratories is all done on the record here as part of the public forum. And Brian, maybe this goes something that you were commenting on before. Are you suggesting that he's going to be speaking? Do you have knowledge that he's going to be speaking about confidential information?
I haven't seen the agenda. They have not published the agenda. My concern is that whatever information has been gleaned as a member of this Forensic Science Commission is going to be utilized as...
So what I'm asking is then, so are you concerned with and are you critical of a member of the commission, speaking in his own capacity, let's say Marvin Schechter or Peter Neufeld or whatever, going out and giving a presentation to a group of lawyers or anybody else that does not involve any confidential information of the commission to say whatever he or she darn well pleases. Is that your concern?
Let me give you my concern. Here is an individual who at one of these meetings in June publicly stated that we were responsible for wrongful convictions in our county. Don't just shy away on this. And then a few moments later was asked to prove the wrongful convictions or to explain why he indicated that, and publicly denied saying that. This is why I'm concerned that this individual now, the same individual who publicly indicated that we were responsible for wrongful convictions, will now be out somewhere in some restaurant in Suffolk County next Thursday night giving his opinions as though they may be the opinions of this commission.
Bob, I think you may be jumping the gun a little bit, but
Barry, I'm not jumping any gun here.
I think I have some recollection of that interchange, but before getting into those details, let me just move back because it's a matter of process and principle. Now, and Bob, you were a prosecutor in Nassau.
Sure.
Okay. When the Nassau crime lab scandal, and there's no other word to describe it, hit, right? The district attorney in Nassau, actually said, well, I didn't know a lot of these things that had been going on in front of the commission. The inspector general criticized this commission, frankly, for not being more proactive in notifying prosecutors, the defense bar, and everybody else, whether that was merited or not, about the details. So let's just assume, for the sake of
let's not assume that.
No.
Let's not assume that, because the statement that the district attorney was not aware of what was going on before the commission, I disagree with, because I attended the meetings.
Listen, just listen to my.
Sure.
I'm just saying that was stated,
Okay.
and I indicated whether one agrees with it or not. Okay. My point is very simple to you. Let us just assume when all these problems were going on in Nassau, and we had these provisional accreditations one after another, right? I or some other commissioner had gone to the Nassau County Bar Association and given a talk that said trouble in Nassau County, that essentially said even though this lab has been accredited or provisionally accredited, you defense lawyers or you prosecutors, frankly, should be taking a careful look at the things that have been cited here as significant events in the laboratory that required corrective action, and went through and reviewed those. Now, are you saying that you would object to somebody doing that?
What I'm saying is a member of the Forensic Science Commission should not be doing that.
Even notifying people in the bar of what was a matter of public record and saying to them, both prosecutors, judges, and even defense attorneys, please pay attention to what's going on here. It's a matter of public record.
My objection is to a member of the commission.
Yeah, I mean, it's a member of the
I think that what's being pointed out here, I think there are valid points being made on both sides, because clearly the point that Barry and Peter are making, commission members, have First Amendment rights. There's legitimate goals in terms of educating the bar, in terms of issues. Now, on the other hand, as commission members, I do think we have a responsibility to think about the integrity of this commission and the work the commission does and the findings that we make. And frankly, my recollection is exactly as these two gentlemen stated with regard to what happened at that meeting with the Suffolk accreditation. I remember Marvin getting very impassioned and giving what I thought was a fairly long talk before the vote, arguing as to why he felt Suffolk shouldn't be accredited. And I was shocked during the course of that talk when I heard him say that Suffolk County Laboratory was responsible for wrongful convictions, because I was completely unaware that any allegation like that had ever been made before. I couldn't imagine that for the first time I would be hearing it right before a vote that never would have been brought up. So I'm the one who asked Mr. Schechter. I said, I'm shocked at this. I've never heard it before. Would you please give me the names of the cases where Suffolk County Lab has done work that have led to wrongful convictions? And my recollection is he did then deny that he'd said that. And in fact, he said it. Everyone makes mistakes, but the problem I have is, there's no bright line rule that says you can't do that. When you put that occurrence together with the title of this program, well, there's not a bright line rule that says you can't do it. And while clearly Barry and Peter have a valid point, and there's some type of balance here, this concerns me, because I do think that there is a point at which, and I'm not the expert, I can't tell you whether it was crossed here or not, but there's a point at which we cross a line and our actions do affect the integrity of the commission. And I think as commission members, we all need to be aware of it. I guess another thing that I don't know that I would be concerned about is this anything that you're receiving any compensation for?
No.
I think that would also raise some serious issues. But I must say that given, I don't think there's a bright line rule, and I clearly don't think there's anything wrong with members of this commission doing continuing legal education, but I think that we need to be very careful about how it's done, how it's entitled, how it's presented, particularly in the context of what happens here at the meetings. And this, just to me, the whole thing from start to finish doesn't look good.
So now, may I speak?
Can I throw one more thing in so you can respond to them all? I just think one of the things you gentlemen have mentioned on many occasions, and it's been cited on the Innocence Project's website, et cetera, is that forensic experts, when they testify in court, there's more weight given to it. So I think one of the concerns, and maybe I'm incorrectly stating this, if it is, you can say that, is that maybe if you're not even saying you're a forensic commission member, that there's more weight to what you're saying. That just like a forensic scientist testifying to evidence is there. And I think we've all seen through the time, and my time is more limited than most here, but right now I could go to the New York Times tomorrow and say, the NYPD, they're a disaster. How many latent print cases did they ruin? This is disgusting. Yet we all saw through an impassioned discussion of how they're actually addressing issues that came up, and we're trying to have a cooperative relationship working with the laboratories. And the thing that I worry about, and I know nothing of the substance, but one thing I do worry about is that there are productive and destructive ways to go about something, and I'm not sure that this is the most productive way for the commission to essentially work with laboratories to make forensic science in a state better, more effective, more reliable. That's my comment. I just figured you can address it at the same time. Thanks.
So let me just speak to the commission members and to people from Suffolk County. First of all, with respect to publicity for this event, which I don't control, I made it clear to the sponsors of the event that there could be no statements made that I was a member of the Forensic Science Commission or coming there as a member of the Forensic Science Commission, although I think that fact is well known.
No, but I think
That's
it's
number
appropriate
one.
that it not be a timetable.
That's number one. Number two, the outline for this particular lecture states in bold letters across the outline that the opinions that I will be expressing are mine and mine alone, and are not associated with any entity with which I'm associated. Couldn't be clearer to anybody who attends that lecture. And third, at the lecture itself, as I do it at all lectures where I talk about forensic science and accreditation, I will indicate that these views are my views and my views only. So the statement in the letter sent on September 18th, 2013, that I will publicly state opinions that might be misconstrued as the opinions of the entire commission, and I'm presenting these opinions and not publicly state this fact that that I'm a member of the commission is wrong. There's no basis for it because, first of all, the lecture hasn't taken place, and I know what I'm going to say, and I know what I spoke to the Suffolk County people about with respect to the lecture. But let me talk about the lecture itself. First of all, this is an accredited mandatory CLE at which attorneys will get credit for attending the lecture. The lecture addresses major areas of public concern, both to the public and to the defense bar. They deal with accreditation, mandatory accreditation, the CFS, this commission, ASCLD Lab, and the Suffolk County Crime Lab. The lecture will touch upon several IG reports since 2008, reporting on lab scandals that have occurred in New York State in accredited labs that were accredited by this commission. But these scandals nonetheless occurred even with ASCLD Lab accreditation. The goal of the lecture is to acquaint the defense bar with what the Commission on Forensic Science does, what ASCLD Lab does, who ASCLD is, what it does, how it operates. It also will acquaint the defense bar, and I think this hasn't been done before, for the first time with how the labs operate. In this case, Suffolk County Lab. And it will show these are the things that labs do. They have manuals, they have books, they have procedures. Sometimes they do things that are wrong or they make mistakes. Sometimes it's technical mistakes. Sometimes it's more than a technical mistake. The lecture will take a look at how the lab responds in the accreditation process to those mistakes. And finally, the lecture will take into consideration what the final result was and what the lab has agreed to do. Now, in order to do that, we're going to give to the attorneys the entire record. They'll have the preliminary assessment report from ASCLD Lab. They'll have the lab's response. They will have the final assessment report, and they'll be able to compare the cars, all 25 of them. I'll speak to some of them, not all 25, but all 25 will be made available. And members of the bar will be urged to take a look and review all 25, both as to the preliminary, the final, and the lab's response. The other thing that's good about this lecture is it will acquaint the defense bar and the attorneys with the ability of what to look for in discovery, particularly under Article 240.21c. One of the things we found in New York State is that the lab technicians almost invariably, in the beginning of their testimony, indicate to the jury that they are working for an ASCLD Lab accredited laboratory. And that has to mean something. That has to open the door. It has to mean that the jurors are entitled to know what that means. But the defense attorneys, and some, by the way, most prosecutors and many judges have no idea what ASCLD Lab is. This lecture will allow defense attorneys to see what it is they can ask for in discovery, making pretrial motions in advance, how to prep defense experts, and how to prepare cross-examinations of prosecution expert technicians, in this case from the Suffolk County Crime Lab. One of the things we've learned about accreditation is that it's not foolproof. The greater proof of that exists within this commission. We've seen that time and time. Now, in this particular case, it's a unique opportunity because there were so many cars with respect to the Suffolk County Crime Lab, some of which Bill Fitzpatrick characterized as technical lab updates, and others which were more substantial. So we'll be able to take a look at those and acquaint attorneys with the difference between the two major groups. We'll also be able to show that the laboratory, in this case, the Suffolk County Crime Lab, but it can be any laboratory, can respond to these by saying, look, the standards that ASCLD Lab has, those aren't necessarily the final be-all and end-all. As this lab did, it indicated that SWGMAT, ASTM, and other organizations had standards that differed from what ASCLD Lab had, and those were offered as explanations. This lab indicated that ASCLD Lab, on many occasions, had passed the lab on repeated inspections. And I think one car, the lab specifically said that we had been inspected in 2002, I think, 2005, 2007, named the dates, the years, and said, we were never criticized for this language, but now we're being criticized for it. So that's a good thing to bring to the attention of the defense bar and to the public. Because if ASCLD Lab is telling a lab that you're okay and then at some future date changes it, and the lab proffers that as a response to a car, then the defense bar needs to know about that. And they need to know about how accreditation is operating. In this particular case, the lab also indicated in response to a car that one of the reasons it did what it did with respect to some of the things that it was cited for was because the New York TWIG, TWG, had not yet published its findings. And so what the lab was in effect saying, because it hadn't published its findings, we're okay with what we did, and that is a reason for us to move forward. And that was particularly important because the lab was very specific in its statements that it felt that a qualifying statement, standing by itself, the word could, was enough, even though their own lab manual in one of the cars said they should have a qualifying statement, and they took it out. One of the things that is important for the defense bar to know, and for prosecutors, and for judges, and the public, is to know that as we sit here today, there is no restriction by this commission, by Askeladd Lab, that prevents a lab from tomorrow morning changing the way it reports. In fact, we have no reporting standards in the state of New York for how reports could be done. A number of the cars in the SCCL's case dealt with a finding that they had not reported in clear and unambiguous language what it is they found. That's an issue. That's something that defense attorneys and prosecutors need to know. So that's what the lecture will cover. It's informative. I think it's educational. It brings forensic science issues and the mysteries of accreditation before the defense bar and the public. And I think it does a good service to do this first in Suffolk County, where it all occurred.
Any comment with regard to how the letter, which from what I
You know,
understand, let me
yeah.
finish. With regard to how the letter, which my understanding is was not a matter of public record, got into the hands of the defense attorney. in that
I don't
case?
know. I don't know. The only people that I sent the letter to was this commission. And I sent it the night, I think it was the night before we voted. I never got a request from any defense attorney in this state for any letter to be used in cross-examination of anybody. I still don't know how that happened. And by the way, my letter, which was to the commission, was an opinionated letter. I think it was very clear. It was my opinion. I asked the commission the night before
I'm not saying there's anything wrong with the letter. Just ask a simple question. I think you've answered it.
Well,
I'm going to make a couple statements here. First of all, yeah, I agree with a lot of what you say in terms of things that would be helpful and useful for the bar and useful for defense and prosecution. But that being said, I don't know how you unring the bell with regard to the statement you made at the meeting. It wasn't accurate, to the best of my knowledge. It was inflammatory. I had no idea what the state. I don't know if it was an accident. I don't know what it was, but it's a bell that was rung, and I don't know how you unring it. Secondly, whether you had anything to do with the title of this program or not, it is entitled what it's entitled, and it is an inflammatory title, if you ask me. And when you put those two together, again, my humble opinion, it creates an appearance for this commission which doesn't sit well with me. That's just my opinion, and it really doesn't mean much of anything because I don't think we have any authority as a commission to tell you to do this or not do this. That being said, I think the only real authority here is the Joint Commission on Public Integrity, and this CLE hasn't happened yet, so I don't think anyone could act if they wanted to. But if after the CLE is done, or I suppose at this point, if anyone feels that Marvin or any other commission member has acted in a way that violates the public ethics law, specifically Section 74 that's been cited, I think the appropriate remedy is to go to the Joint Commission on Public Integrity. But I don't see that this commission, with our limited scope and our limited role, has any legal authority at this point to tell a commission member, to do something or not do something, particularly with regard to the First Amendment issues that have been raised. So that's the way I see it right now. I think I've expressed some opinions. I think I've expressed some thoughts in terms of what our authority is. And I really don't think as a commission, I appreciate you raising it, but I don't think we have any other authority as a commission to do anything else at this point.
We just came to express our concerns. I know that was Mr. Jenner's, as was mine.
And just for the record, it's going to be extremely awkward for myself and other members of our laboratory to openly discuss questions by Mr. Schechter in the future. Right now, it's awkward for me to be here. I've never had that feeling in the past, but now that this individual is doing what he's doing, it makes it extremely awkward for us to deal with this individual, to answer his questions, and to be concerned that what our answers are going to be may be misconstrued and misinterpreted and give at a future lecture that he may be giving. I just want that for the record.
Given the comments that I've made, and I think I've made them pretty clearly, I understand why, taken in the entirety of what's happened, why you would feel the way you do.
Thank you.
Thank you.
Thank you very much.
Ann, did you have something you wanted to add?
Well, that I concur largely with your comments, Mike, and that I think, unfortunately, while many of us as members of the commission enjoy and take seriously the opportunities that we can offer to educate the community at large and on issues of lab quality, lab accreditation, and the functions of the commission. But that can be accomplished without reference to individual laboratories or individual documents or cars, but more in an example kind of composite way. I do think, Mr. Schechter, unfortunately, for all of your good intent, you risk referral to JCOPE for violation either under 74B, C, or H. And that is a recourse that those who have expressed their concerns may have.
Question? I don't know if Marvin, you can answer this, but is this presentation you're giving going to be taped so that it can be reviewed perhaps to see if there were, I think, the concern that I have is sometimes, I think, my opinion, I've heard things that seem inflammatory, like instead of using the word corrective actions, we use the word lab scandals. I mean, that kind of thing I think is a concern, and I think if maybe we could see a copy of the presentation, or if Suffolk County could see it, I don't know if they're allowed to be there or not, it would help us know, are things being mischaracterized? Because I think that's a concern the lab directors have. It's one thing if there's factual information being presented, like you say, the corrective actions. Another thing if someone's going to say, this is how the laboratory responded, rather than here's a document, or this is how I think they responded, this is what I think they said. Those kind of things are disconcerting to me.
Well, I don't think it's being taped. That's number one. At least I haven't been told. Number two, I think that I leave it up to the audience that will have in front of them the corrective action requests, both the preliminary, the lab's response, and the final report. And I intend to discuss those. And I think I have, opinions that are clear. They'll be based upon the CARs. They'll adhere to the CARs, particularly the lab's responses. And what I think defense attorneys need to do in the preparation of a criminal case where they represent a client, what they need to do when they seek discovery and they see those kinds of responses. I think that's important. And I think that's, I don't know that you can, under the First Amendment, curtail my opinion about different things that are not only a matter of public record, but the views that I have about those cars. Now, in this particular case, there's not much for me to do. The cars speak for themselves. So I don't really have to go too far, but merely just point out, here's the response to the car. I mean, one of the things that was pretty telling about one of the cars was the HEMA trace test that was referred to in two of the cars, and the explanations that were given for that.
Peter's got a very important issue he's got on here that I want to make sure we get to. So I'd like that we can put this one to rest.
I'd like to put it right. I just, one thing I want to just clarify, because Ann seems to be implying, and if we can say this much, that Public Officers Law 74, 3B and C, which refers to the engaging in any professional activity which would require disclosure of confidential information gained by reason of official position, right? And prohibitions against revealing confidential information. Now, Mike, I don't think that you're suggesting, are you, that by disseminating what is a public record with respect to these corrective actions, just by that alone is distributing that to an audience, that Marvin is in violation of this rule? That's not confidential information.
Yeah, I guess first I would say that I'm not the one who gets to interpret that rule.
I understand that.
And secondly, I don't think that was at all what I said. I think.
No, I didn't think you said that. I don't think you said that. I thought Ann might have suggested that.
In the overall context of everything that's taken place, and some bells that have been rung that aren't capable of being unrung, this leaves me with a very uncomfortable feeling in my gut about the integrity of the commission going forward, and particularly with regard to our dealings with Suffolk. But I absolutely understand, respect, and agree with the things you and Peter have stated about people's First Amendment rights and education. And somewhere
There has to be a
there's gotta
balance struck. I
balance.
understand that.
I'm
and-
not the one who gets to decide how that
Right.
gets struck, and I don't want to keep beating this horse.
No, I don't want to beat it, but I just want to, I felt I had to say that because I don't want Ann's remarks to be construed as saying that if you refer to documents that are public record that are before the commission, that you violate a provision of the code that...
That's certainly not my interpretation.
Okay.
Now, I think there's
But,
just one housekeeping matter.
Can I defend? That's not what I said.
Okay, good.
What I said
Good.
was he was at risk for referral under that clause, but I also said Clause H, which is simply the appearances of having violated the trust of his position.
And I'm going to
have different
exercise my
penalties.
prerogative as chair and say that we've finished our discussion on this issue. We have one quick housekeeping issue, and then we have a matter of new business that Peter wants to address.
My apologies for shuffling us through old business very quickly, but if you look under old business also, at a previous commission meeting, there was a question about Ascot Lab and ABFT and their accreditation deadlines. So I sent a correspondence to both of these agencies. They both responded. I think the documents speak for themselves. I don't think we need to belabor the point. I think if we do, we can definitely have more correspondence about this in the future. But both of these accreditation providers have been very forthcoming about the dates that they would have to have laboratories submit in order to maintain their accreditation cycles. So with further ado, we've got old business done. We're back to the last item of new business. Peter?
The last item we have in new business, it relates to a memo Peter sent, and I'll let Peter start on this issue.
Sure. The memo is fairly comprehensive, but because we have about 40 members of the public here,
What you say, 40 minutes.
No. I will go into a couple of minutes of explanation, that's all. This is a request asking that the commission begin to move the machinery forward to enable New York State to conduct a review and identify a subset of cases from local and state crime laboratories where people who were involved in hair microscopy made positive associations, wrote a report and or testified, where convictions resulted, okay, where there may have been, not saying there was, where there may have been scientifically invalid statements made by the local or state hair microscopist. The basis for this request, for a long time, obviously in the 1970s, 80s, and 90s, and apparently from what I've heard, some laboratories in the state continue to do hair microscopy and are not utilizing mitochondrial DNA testing. But for many decades, hair microscopy was used by state and local crime laboratories and by the FBI in cases to help identify the source of trace evidence found at a crime scene. And what happened is that the FBI decided, after reviewing a series of cases where people were exonerated, where hair evidence had been used against them at trial, where they went back and looked at the transcripts, and the FBI crime laboratory decided on its own that the testimony that had been provided by their own hair analyst was scientifically invalid. And they also acknowledged during the course of this review that beginning in the late 1970s that they embarked on setting up a training program to allow young or experienced hair examiners who work for state and local crime laboratories around the country to participate in a 2-week training program at the FBI on hair and fiber evidence. And that part of that training program involved discussions about ways in which examiners could discuss the significance of positive associations. The FBI decided, after seeing these first 3 cases where there were exonerations and looking to see that nationwide, that there were now, in this memo I said 72, there are actually 74 cases where people were convicted where hair microscopy evidence was used to inculpate who had subsequently been exonerated by DNA, that most of the examiners in those cases were state and local examiners, not FBI examiners. So the FBI decided that they had a duty to correct this error. And to implement that duty to correct, what they decided to do was to work with the Innocence Project and with the National Association of Criminal Defense Lawyers to review, to identify all the cases where FBI hair microscopists had, number one, done hair work Number 2, made a positive association. Number 3, a conviction ensued. Number 4, if so, was there a transcript? Okay, is there a report? And what they did is they've been able to find the reports of that entire subset of cases because, at least going back to 1982, because they keep duplicate copies of the reports in their laboratories.
How did they find those reports?
So, and that's something we brought up because obviously there's a difference between the way they might do it in their laboratory and in New York State where you have perhaps a dozen different laboratories who have had microscopists who have different ways in the laboratories of retaining reports. The way they did it at the FBI was for cases going back to 1985, they had a computer log, which made it easier. And cases going back before 1985, they did it by actually paper inspection.
So they could actually get on a computer and put in hair?
No, what they could do is they could go back and look at cases that came to the laboratory, and then once they got to the laboratory, there's like a traffic cop who says, I want this evidence to go out to serology, to go to hair, to go to glass. You see what I'm saying? And so then they could look at those that went to hair, okay, and there would be a log there. So for instance, it could be the case, and then for the older cases, it was a little bit more challenging, but they were able to identify so far all the cases by hand back to 82. I had a brief conversation with Catherine Levine about some of this because Catherine, unlike all the other people who sit at this table, actually did hair microscopy for a couple of decades. You don't look at...
No.
A decade?
15 years.
Okay, 15 years. Sorry about that.
That wasn't very nice.
I said is that you don't look it.
Removed from the commission.
Right. It couldn't be more intemperate than that. I apologize. In any event, Catherine's been very, very helpful in giving me sort of the big picture of what hair microscopy was like in New York State during this period of time. So what the FBI is doing is they've narrowed it down to, and you got to remember, this is the entire country. So for a long time, before the mid-'80s, most of the hair microscopy testimony in the country was coming from FBI hair examiners, not from state and local. But as more and more state and local examiners got trained, the balance began to shift to state and local. They have identified at the FBI 2,100 cases where FBI analysts made a positive hair association. And what they're doing is they're also working with the Department of Justice and they're working with law enforcement to then try and find the transcripts in those cases where there was a positive association. I think Catherine said you thought, at least during your tenure when you were in the state laboratory, was the practice to keep duplicate copies of the reports.
Well, the reports would go into a case file, which would be kept.
Right.
And the originals would be, or copies would be sent to the various agencies that submit it. So there's certainly a report in the files.
So at least for hair cases in New York State Crime Laboratory, there may be a method to identify that subset of cases. Now, obviously, at the FBI, what they decided to do as part of their protocol is once they identified that subset of cases, they worked with prosecutors, okay, all over the country, to get the prosecutors to cooperate to find out, number one, was this a case which resulted in a conviction? And number two, if it did result in a conviction, do you have the transcript? And in most of the cases, the prosecutors are able to locate the transcripts. And if they couldn't locate themselves, then they asked the people at the NACDL to try and contact defense attorneys or other people who may have been involved in the cases back then to see if they could get a copy of the transcript, either through the Appellate Division Court Clerk's Office, which may have a copy of the transcript, or some other entity. So then they were collecting the transcripts, and that's what they're in the process of doing right now, collecting the transcripts. Then they review the transcripts, and they determine whether or not any of the errors which you all have now in a document that was prepared by the FBI and that was distributed for you, which describes the three types of errors in testimony and report writing. And what's interesting about those three errors is, unlike the discussion we had several months ago about problems in hair microscopy, that even if a laboratory included that disclaimer in its report that the hair is not a means of individualization, or even if they said in the report that the hair could have come from somebody, in other words, limiting language. Nevertheless, if when they testified they made any of these three types of errors, the FBI concluded that that testimony was scientifically invalid. And they weren't making materiality assessments because they felt laboratories should not be making materiality assessments. That's a lawyer's and a judge's job. And so all they're doing is, in all the cases where they identify one or more of the three types of errors, they will be sending out notification letters. They're sending out notification letters to the prosecutors, and I think I may have even attached a copy of the notification letter here. Did I, Brian?
I can't recall.
Okay. If I didn't, I can get you all that in the interim, what the form letter looks like. And then approximately a week later, they're going to be doing disclosures to defense attorneys. The problem with defense attorneys is that, particularly in a case that's 20 years old, that defense attorney may be dead, retired, or at best might not care anymore. Okay? So they asked then the NACDL to take on the responsibility of reaching out to that particular inmate and saying, you know, are you represented? If you're not represented, is this an issue where you want representation? And then those lawyers will do an investigation as to whether or not they think it's material. They can engage in conversations with the prosecutor. The prosecutor can agree or disagree, and whatever happens then, happens then. But at least the laboratory understood its own responsibility to try and correct this error. And then after the FBI decided to embark on this particular strategy of reviewing these cases, ASCLD Lab should really be commended. In April of 2013, issued a memo or a notification to all of its members, and in their memorandum, ASCLD Lab said that each laboratory, meaning on a state and local level, in consultation with the appropriate legal authorities, needs to consider whether there may be past cases from their own laboratories, specifically involving convictions, in which it would be appropriate to evaluate the potential impact of the reported conclusions and or related testimony on the conviction. In other words, I'm sorry.
No, it's Kathy and I got to get to the airport.
Okay, I'll cut to the chase then.
Well, I totally agree with you.
Right.
I'm just worried about, it seems that you got judges, prosecutors, defense lawyers, the inmates themselves, and the lab. And I don't know that the lab might be the least efficient way of I mean, I don't know any, Kathy, correct me if I'm wrong, and any lab director in the room, please speak up. I don't know that a lab can go to, like the FBI can, and say, this was a conviction based on hair.
No, it's not a conviction based on hair. All the lab is doing...
Or testimony.
No, not even based on. All the lab is doing is saying, was there a hair examination done? Was a report issued? Was there a declaration of a positive association? Period. That's all the lab is doing.
And then it goes to?
And then it would go to, from there, okay, once that's done, then there is a unit at the FBI. In this case, it's the Office of Legal Counsel at the FBI that's contacting law enforcement and prosecutors to find out, one, was there a conviction, and two, if there was a conviction, is there a transcript?
Can you do that in our lab?
The first part?
The identification of...
Yeah. This is the issue that we do have to leave, so if I could just run through my concerns,
sure,
and then maybe you can discuss. I think I spoke to some other lab directors as well as what I know from within my own laboratory. It's an issue because if we're depending on how far back you're going, but prior to probably the year 2000, most labs did not have a limb system. So they may or may not have records of if it was a hair case. They may or may not have records of who the analyst was. I mean, it's depending on what we're looking at, it's a significant undertaking. Labs, you basically might be asking them to review every case they've ever worked to find hair cases. Each lab is going to be different. Those are going to be issues. Is it possible you just want to look at homicides and sexual assaults, or do you want to look at every case? If you're asking labs, if they don't have a way to identify their hair cases through a computer system, that's manually reviewing. There's issues about where the case files are located. You know, there's cost, the time for people to do it. It's going to be a lot of cases. I'm not saying it can't be done, but we're going to either need funding or people to help us do that. I think a lot of these issues need to be brought up. In addition, you're only talking to the labs here. My lab wasn't in existence before 1999, so what are you doing about the police departments that may have been running the labs before or whoever else? It's not just the current labs you have to ask about. My other question was, when you speak about, let's say we can identify all the cases, and then you're saying you want us to identify positive hair associations. I mean, some positive hair associations may not be probative. For instance, if it's a victim sexual assault kit and the hair examiner said the pubic hair combings identified hairs consistent with the victim, that's positive, but it's not probative, so you need to kind of define that.
Well, it just answers that little question. That is defined by the FBI. In other words, there are only two positive associations that are looked at. One is a positive association to hairs found, let's say, on the victim that can be positively associated with a particular suspect, or two, hairs found at the suspect's home, in the suspect's car, or the suspect that can be positively associated with the victim. So in other words, it's only positive associations that are in fact inculpatory.
And so I think the bigger concern that the labs have at this point is, are you talking all cases or just a subset of cases? And secondly, most labs probably do not have a mechanism to identify hair cases. I mean, some might, I can't speak to all, but the few that I talked to said going back to a certain date, they would not be able to do that other than reviewing every single case file, hand reviewing.
So here's what I would suggest doing, because I think, frankly, that Kathy is raising excellent questions, okay? And obviously, it's not a one-size-fits-all situation. What I would like to get out of this body today is, number one, at least, and I've talked to some people, a consensus that we do have a duty to at least look into this to see what kind of review we can reasonably accomplish. So in other words, just accept the principle of a review given the ASCLAB lab memo, the FBI hair review, the statement on what's scientifically invalid, that reality. Number two, what I would suggest doing is the following, that between now and the next meeting in December, that we create a small subcommittee, okay, which would have Kathy on that committee, would have you on the committee, Bill, because you would think about the questions from a prosecutor's standpoint, that would have Kathy Levine on the committee, because Kathy, more than anybody else here, has that institutional knowledge of what labs were doing hair microscopy, who the hair microscopists are or were, and she could help Kathy, for instance, and us to contact the appropriate entities and people so we could learn more information to answer Kathy's questions to see which labs can do something, which labs can't, and the ones that can, how much can they do. And that would also include Marvin, because if there's going to be a notification component and you're going to need defense lawyers there, Marvin could be very useful for that particular purpose. It would include me only because I'm the person who for the last 16 months has personally collaborated with the FBI on this protocol. And all we would do is then report back at the next meeting as to what kinds of problems exist at the different laboratories in New York State that have this kind of problem. And I would hope that that kind of...
Peter, they need to leave. So can we just make a motion that the 5 people that Peter just enumerated form a working group, analyze this issue, and come back at our December meeting and give us recommendations with regard to...
Yes, that would be a friendly... That's a good motion with one other point, but it's also the sense of this body, though, that at least in principle, we should make whatever reasonable efforts we can make to do a review of that subset of cases.
You're going to lose your votes if we don't.
So, I mean, that's it. That's the motion. So I'd ask you, Bill, to stick around just for a vote on the motion.
I already sent out a survey to the 62 electeds, and there's some that still haven't responded. But it's a minuscule number of people that have responded.
Right, but I'm just asking for your vote now.
You got it. Yeah.
Okay, so that's one vote. Can we have a...
Understanding that the way you've worded the motion, we agree in principle that this is a serious issue that needs to be addressed, but we're not agreeing to any specific way to address it until we get feedback from this working group.
That's correct.
That's right. The feasibility study at this point, correct?
That's right. That's a serious issue that needs to be addressed to the extent and the manner in which we decide to do it is something that will be addressed at the next meeting.
Okay.
The only modification...
That's the motion.
One quick modification, just in light of our last conversation, maybe if you could just put Barry on it instead of Marvin, just for now, because you're going to be dealing with the Suffolk County lab. And again, this is kind of the situation where one thing leads to another. That if you just swap it off, you guys have been doing this on a national level, it shouldn't be a problem, and then you report back and then we'll figure it out.
I don't see why the Suffolk County thing has anything to do with this.
Well, I think they just expressed to you that they feel uncomfortable even talking to him. And I think what happens when you're looking for cooperation with the labs, it makes it difficult.
He doesn't have to agree with, he doesn't have to deal with them.
No, the people who are going to be dealing with the labs, Brian, are probably going to be Catherine and Kathy, not me either.
You've made a motion. Do we have a second?
I second.
All in favor? Anyone opposed? All right, motion carries.
Thank you.
All right, do we have a motion to adjourn?
Yes.
Second.
Second.
All in favor?
Aye.
Thank you, everyone. I really appreciate your time and
Thanks.
effort. Take care. Good luck. Take care.